Brother Kardak, you are there?
Yes, yes.
The appeal has been allowed.
The respondents put a hoarding in my land that was removed, my lord. So presently, my lord, there is no further action, my lord.
Okay.
So,
Three G and Sayola Learned Senate Council assisted by
TJ Sahib.
TJ Sayola has submitted that the cause of that during that after filing of this writ petition, the cause the existing there is no existing cause of action as the hoarding has been removed. Also heard yes, and thus
yes,
J. Hendrik Learned State Council, in view of the above submission, writ petition is closed. Yes.
well, if in future, any again,
That is a fresh cause of action.
Wait, please, Your Lordship. With the consent of the other side, I beg to mention item number 37, my lord.
Yes.
May be taken after 2 weeks.
After 2 weeks. Why?
My lord, I was supposed to file the affidavit. The affidavit is ready, but I'm told that, my lord, recently on the same subject matter, the Apex Court has rendered a decision, my lord, that would cover. So I'm waiting for the judgment, my lord. Copy of the judgment.
But file the affidavit.
Yes.
I have informed the other side.
Yes, yes.
On a request made by Sri B. Sharma Learned Council for the railways. Matter is adjourned by 2 weeks. Put stop. In the meantime, affidavit in opposition may be filed.
wait, present.
Yes.
Lordship, I pray for listing of two alternate petition on 6th, Lord. Wednesday, Lord.
Bench 5 matter.
Yes, Lord.
Okay. The 6th will be sitting for 1/2. Okay, try it.
6th, Lordship, in this case,
What is the urgency?
urgency is, Lordship, the petitioner is an LOT of the government of Assam.
Okay, motion will not ask for urgency. Day after tomorrow, no problem.
Yes.
My lord, may I please the lordship, my lord, eviction matter, my lord,
When?
tomorrow, my lord.
Okay, try it tomorrow.
Oblige, my lord.
May I please, I beg to, with consent of the others at my lord, I beg to mention item number 26.
26?
26.
Yeah.
The arguing council,
26 is a 16 matter.
lordship, but the arguing council as whatever is out of station, my lord.
Who?
The date may fix after 11th,
Who is out of station?
as whatever.
16 matter we heard, we don't normally adjourn. Sri S. Request has been made on behalf of Sri S. Waterford Learned Council for the petitioner. Full stop. No, for adjournment, request for adjournment, huh? Fair. However, considering that this matter is pending since the year 2016, slight accommodation is granted, directing listing of this matter on
Any date after 11th,
13th.
lordship.
No, 13th, not 12th.
Lordship.
12th. This will be item.
Obvious.
12, item number 26. Yes.
My lord, may I please, lordship, I beg to mention for listing on 7th, my lord, 2 eviction matters.
Listing of what?
For orders, my lord.
Orders matter which year?
2025, my lord, eviction matter, my lord, there is an interim order which, my lord, will going to be, my lord, over.
If it is not listed, it is still the returnable date.
Returnable date was 6 weeks, my lord.
If
before.
it's not listed, it gets automatically extended. It's not your fault. Yes, next.
My lord, next week.
We don't allow this kind of mention memo unless you show some urgency. This is out of turn listing.
Alright.
Motion is different. Yes.
Item number 29, Lordship.
Yes.
Lordship,
18 matter.
Lordship.
2018 matter.
Lordship, Dr. Ankit was also arguing this matter. Lordship, thing is that there is some medical urgency, Lordship, due to Lordship today, he cannot come, Lordship. I have taken the consent from the other side, Lordship.
Okay.
In the next.
Item number 29. A request has been made on behalf of Dr. A. to the Learned Counsel for the petitioner who has been stated to be unwell. Request has been made for adjournment. For adjournment. Para? In view of the above, matter is adjourned to be listed after 1 week.
Lordship, and the next week, Lordship.
1 week.
13 or 14, Lordship.
1 week we have said 1 week. Yes.
May it pleases, my lord.
Yes.
My lord, with respect to item number 11 of today's daily list, my lord.
Yes.
On the last Friday, we have filed our affidavit in opposition, my lord. We may be allowed to bring it on record. Obliged, my lord.
But you beg to mention item number 4 and 5 of the daily list.
Yes.
So as Bothakur is out of station. You inform the other side also.
Have you informed?
Lordship, I am appearing on.
Yes,
behalf
yes.
of
And
respondent.
when?
Uh,
Why these are specially assigned?
Wait to 4 and
4 and 5?
date may
Hmm.
be fixed.
Criminal matters, why specially assigned? I'll do now. Okay, when do you want?
Lordship, either may 21 of August or 22 of August.
Okay. A request for adjournment has been made on behalf of Sri S. Bothakur, learned counsel for the petitioners. There are also heard Sri so standing PP and I. You are Bharadwaj.
D. Bharadwaj.
Para. On request list on 22nd,
20 seconds.
22nd of August.
Obliged.
Much obliged, Lordship.
May I please, Your Lordship?
Both matters, 4 and 5.
Yes, yes,
Okay.
Yes, sir.
Yes,
yes, Lordship. I beg to mention item number 34 of the daily list, Lordship.
34, yes.
This matter may be taken on the next week, Lordship, any day, Lordship. Today I have some difficulty.
34.
34.
Here for whom?
I'm
Petitioner.
petitioner, Lordship.
On a request made on behalf of the petitioner, matter is adjourned to be listed after 1 week. Yes.
Obliged.
My please, Lordship. Lordship, item 15 of the daily list may be adjourned for the day.
1-5.
One side.
On a request made on behalf of the petitioner, matter is adjourned to be listed after a week. Yes.
May I please, Your Lordship? As per last order, my lord, we are filing affidavit today, my lord. I have already served the copies, my lord. The matter pertains to my lord. Case, my lord, 22 kindly see, my lord. Notice was issued to the, my lord, petitioner to, my lord, dismantle the house, my lord, constructed nearby the, my lord.
Who's for the other side?
PWD.
Public Works Department. Mr. B. Chaudhary.
But construction was made in my partial land, my lord. Whether without acquiring the land, my lord, they can, my lord, issue such notice, my lord. That is the question, my lord.
Yes, you have the instructions, Mr. Chaudhary.
No, my lord.
24 matter, why is it for motion?
Notice may be issued in the meantime, my lord. You may file affidavit.
What are your instructions, Mr. Chaudhary?
Lordship, I have not received any instruction.
Instruction was received, my lord.
1 year.
Last order, the inspection was placed, my lord. The inspection was there, my lord. The construction was made after the, my lord, grease was constructed, my lord. At last order, kindly, my lord.
Lordship, there is an instruction of December 2024. That's it.
What does it say?
Lordship, there is no permanent structure at the location pointed out by the petitioner. And it's only for the laying of foundation. Don't stay. Lordship, may kindly pay it.
No, that was also reflected in the order of 19/12/2024
Yes.
of this court. This instruction was placed before this court.
Yes, ma'am.
You file this on affidavit. This matter is coming after around 8 months. You have not filed the affidavit. You are not, it seems you are not serious about the matter.
Lordship, a week's time, Lordship. I'll
8
file.
months, if you don't file affidavit, how can we help you? And why should this matter remain in the motion for more than a year? We don't understand this. Okay. Heard Sri H.R. Ahmed, learned counsel for the petitioners. Who is aggrieved by a notice dated 14/11/2024 issued by the Assistant Executive Engineer, PWD, Bir Singh Jarwa, Territorial Road Subdivision, Vilasipara, whereby the petitioner was asked to dismantle and remove the Assam type house by 30/11/2024. The petitioner claims that the structure is on the patta land of the petitioner. This petition was taken up for consideration on 27/11/2024 when instructions were directed to be obtained and an interim order was passed. The order dated 19/11/2024 reflects that instructions which were obtained by the Learned Standing Council, PWD, were placed before this court, and accordingly an affidavit was directed to be filed, which is yet to be done. Let notice be issued, returnable by 4 weeks. 3. D. Chaudhary, Learned Standing Council, PWD, accepts notice on behalf of respondent numbers 1 to 5.
Yes, ma'am.
J. Hendrick, 6, State Council.
3 and 6.
3 and 6. Oh, 1 to 5, no, 1, 2, 4 and 5, 3 and 6. Let extra copies be served by the returnable date. The affidavit by the PWD is required to be filed. The interim order passed earlier to continue till the next year of listing.
Objection.
Item 24 matter, why 24?
On item 2, Lordship would see on 29/11/2024, the detailed order was passed. Probably, my lord, the word issue notice was might have missed out in this order. So therefore, it
It
has
was
come
not
in
missed
motion.
out. It was not issued.
My lord,
It cannot be missed out. Notice was not issued.
my lord.
Even the last case we have seen, notice was not issued.
And fixed returnable date was not fixed, so therefore it didn't come up, my lord. Again, therefore, it's coming for motion.
No, there was a direction to list after 4 weeks.
My lord. Since there was no fixed date, probably, my lord, they still could not list it.
What about the earlier case?
That is
59?
pending for admission, my lord. In this case, my lord, no affidavit has been filed.
Oh, you have received this. How can we issue a formal notice?
My lord.
How it's be Pathak, Learned Counsel for the petitioners. The petitioners have approached this court with an apprehension that their properties would be demolished in the process of expansion of road without making a demarcation. What's the para? This matter, it is also the case of the petitioners that similarly situated persons had approached this court earlier in WPC 59 of 2024, which is pending. When this matter had come up for consideration on 29/11/2024, the respondents, the Learned Counsel for the respondents were directed to obtain instructions. No, don't say para. Sri J. Hendrick, Learned Counsel Landscape Council submits that instructions have been received. Let notice be issued, returnable by 4 weeks. Revenue Department, Ms. G. Hazarika, 1. 2 also what? District
One or two or three, four.
1 is Hazarika, 2, 3, 4 Handik, 5 and 6 B. Chaudhary. Okay. Uh, Since the Learned State Council has received the instructions, let the affidavit be filed by the next date. What is the position now?
My lord, the expansion partly has taken place. In these cases, my lord, they have not touched the land till now,
Okay, it may not be, it might become infructuous also.
my lord.
Okay. Next.
My lord, the interim
Is
protection.
there any interim
My
order?
lord, without due process of law, they should not be displaced, my lord.
Where is it?
Observation is there. The last line, my lord, last para. And in the meantime, during the pendency of the petition, unless proper procedures are initiated for acquisition, affected persons.
Okay. The interim order passed earlier to continue till the next date of list.
Keep your right.
Item 3. Who's the counsel? S.B. Laskar. Where is Mr. S.B. Laskar? None appears for the petitioner on call, whereas the state is represented by G. Handik and the Revenue Department. Are you a party, madam? And the Revenue Department by Miss G. Hazarika Pera. When this matter had come up for consideration on the last occasion, that is 11/12/2024, it was submitted on behalf of the respondent that there was an objection filed by 6 persons against the application for issuance of NOC by the petitioner. Full stop. Oh. Be that as it may, and in the interest of justice, the matter is adjourned by a week.
Right. On compliance of the order started from page 10, my lord, and operative part at page 14, my lord. Last paragraph, my lord.
Page,
Page 14,
what is it?
last paragraph, my lord. In the light of the above direction and observation made in WC so this repetition is and dispose of with the direction to the concerned Deputy Commissioner on receipt of such claims, he shall make an inquiry whether the accident took
Yes,
place.
how do you overcome limitation?
My lord.
How do you overcome limitation?
Regarding limitation, my lord, I have explained in paragraph 7, my lord. My lord, actually, the deputy commissioner was given assurance to pay the,
That is not enough. These are having penal consequences.
and
Matter the
finally, my lord, on 23/7/25.
petition, the order is of 2021.
Yes, my lord.
4 years have passed.
Yes, my lord. Last on, my lord, 23/7/25, the petitioner visited the office of the
Not enough.
district commissioner, my lord.
If you are not diligent, and there is a law, statute.
Yes, my lord. But regarding.
Part 3 M. Hussain, learned counsel for the petitioner who has filed this application alleging willful and deliberate disobedience of the order dated 19 2021, passed in WPC 977 of 2021. Full stop. By the aforesaid order, comma, the deputy commissioner was given certain directions. Full stop. The petitioner has annexed our representation dated 3/3/2021 to the aforesaid incumbent. Full stop. As regards the issue of limitations, comma, the learned counsel has submitted that the petitioner was given assurance and has drawn the attention of this court to paragraph 7, full stop, para, the contempt of court. Under section so and so of the Contempt of Courts Act, the limitation is prescribed, full stop. Though this court can also exercise powers under Article 215 of the Constitution of India, comma, for that an appropriate case is required to be made out, which has not been done in the instant case. Full stop, para. In view of the above, this petition is dismissed on the ground of limitation.
My lord, regarding limitation, my lord, I
Section
rely on
50.
judgment, my lord, for not safe, my lord.
Where is your explanation?
Explanation, my
That is
lord,
not done.
my lord, I have explained in paragraph.
We have seen 7. That is
Yes,
not
my
enough.
My
What is
lord,
the judgment?
paragraph 44, my lord. 44, last line, my lord, within a period of 1 year from the date on which the contempt is alleged to have been committed. my lord.
Yes.
And in this case, my lord, last, my lord, 23/7, the petitioner visited the office, my lord. Then,
At the mother degree. On the issue of limitation, the learned counsel has relied upon relied upon the case of Pallab Sethi versus Swensu reported in 2001, 7 SSC 549 and paragraph 44. And the observations made by the Honorable Supreme Court in paragraph 44 is pressed into service. For ready reference, the said paragraph is expected herein below. The aforesaid observation quoted above has don't write this. The learned counsel has submitted that the cause of action has to be construed from which date?
23 July 2025.
23 July 2025. What has happened then?
My lord, on that, my lord, the petitioner visited the office of the.
On which date the petitioner had visited the office of the deputy commissioner. The aforesaid submission, apart from being fallacious, would also not be supported by the observation made by the Honorable Supreme Court. Full stop. The cause of action in this case would arise from expiry of 1 year from the date of the order, or with an extended period of 60 days, which was observed in the order itself. Rejected it. Yes. Motor देखो
Obliged.
I plead your lordship, my lord.
Yes.
Regarding non-issuance of permission for registration of land, my lord, sale transfer, my lord.
Where is the order?
Last, my lord, kindly turn to page 24, 11 part, my lord. 11
Page,
the
page.
page 24. The last paragraph, paragraph 33. my lord. As the rejection order has been set aside, it is now the obligation of the designated public servant to consider the application submitted by the petitioners for the notified public service, composite land sale transfer, strictly in compliance of the provisions of section so and so. The provision to section 21A of Restraint Act as amended by the Rejection Assam Amendment Act 2009 notification stated 11/11/22 and thereafter to pass a speaking order, my lord, next page, order within the period of 3 weeks from the date of submission of a copy of this order.
Why
by
have
the-
you made the additional chief secretary a party?
My lord, initially principal secretary was the party, but now there is no principal secretary post. I have tried.
Direction is to who, is given to whom?
Particularly, my lord, the deputy commissioner,
Then,
district commissioner.
then, in a
So,
contempt, why do you make a person who was not even given any direction?
being the higher authority and was the
Then
party,
you make the chief secretary a party,
if your
then
lordship,
the union government a
if
party.
your lordship thinks so, maybe.
No, it's not, if your lordships. It's nothing to do with the court. You have to relate the order with the person who has been given some directions.
My lord, maybe deleted if so your lordship thinks fit.
Don't make this kind of things. This is resorting to unnecessary harassment to an officer.
My lord, being the party,
Show us the direction, we'll make him a party, we'll issue notice. Why this kind of things?
my lord, being the party in the petition, that's why I made all the mass.
Then you make, what about the other parties? Only 2 parties were there in the petition, writ petition, let us see. Who were there in the writ petition? There are four respondents. What about the others?
My lord, the senior sub-registrar and sub-registrar,
Yes, why not?
it has not gone to them, my lord. It is remained above them.
Above
if-
them, confined to whom?
If the my lord, permission is issued, then they're engaged in.
Then what is the role of the first respondent here in this contempt?
My lord, first respondent, my lord.
Yes,
My lord, being the higher authority of controlling authority, I have made. My lord, your lordship is made deleted here for not doing, my lord.
don't leave it to the court. Why should the court apply its mind? Don't you think that it is the duty to point out who is the person to whom something has been directed?
My lord, kindly see, my lord. Thereafter, my lord, kindly to take to page 26, my lord. The docket number, memo number, all are here. Then
We
I have
have seen this. This has been addressed to whom?
deputy commissioner.
Deputy Commissioner.
Yes, that is true, my lord.
That this first respondent has not even been made known. There is no role to be played at this stage.
My lord,
Heard Sri A.K. Talukdar, learned counsel for the petitioner who has alleged willful and deliberate violation of the order of this court dated 5/5/2025, passed in WPC 1493 of 2025. Full stop. The order has been perused, whereby certain directions have been given to the designated public servant to act upon the application of the petitioner. The representation dated 15/5/2025, forwarding a copy of the judgment, is also addressed to the district registrar cum district commissioner Sri Bhumi. Full stop. Para. It is however seen that the additional chief secretary to the government of Assam Revenue and Disaster Department has also been made a party. Puts the para. Be that as it may, let notice be issued, which is confined to the respond number 2. Let steps be taken for service of notice upon the respond number 2. Be taken by registered post with any steps within to this.
my lord, dosti may be allowed kindly.
Lost in contempt.
My lord,
First day.
my lord, very
Under what provision?
My lord, one person is.
Under what provision?
My lord, your lordship to power.
What provision? Tell us that they have
power-
not accepted, you have not been able to serve them. Why does on the first date?
My lord, one person is very old, my lord. Anything may happen anytime, my lord. Everything will go in vain. That's why we are in a.
Contempt matter is, what is the urgency? You are making an allegation
Only-
that they have
only if-
violated.
If it goes, my lord, they may be active on the.
Don't make this kind of prayers. You think over, you are an officer of the court. Think over when justice can be allowed. Yes, next.
My lord, the date may be kindly fixed, my lord. Yes, my lord. So that-
We have them returnable 6-6. Registered post. Yes, next.
How like that?
Yes, Mr. Fukan.
So order dated 6/12/2024, Lordship. The relevant paragraph is at page 16, Lordship,
1-6.
1/6, Lordship.
Yes.
From, it starts from line number 11, Lordship.
Hmm.
Hello. May I read, Lordship?
Yes, please. Under
such circumstances, while disposing of this petition without interfering with the order dated so and so passed by the District Commissioner Hailakandi, the petitioner is granted liberty to file proper application before the competent authority for allotment of land for homestead in rural areas. If any such application is filed, the authority competent to deal with will examine the matter in the light of clause 3 of the-
where is that mandamus? There is no mandamus. Liberty, then if you file.
And Lordship, it's not a time-bound manner also. But Lord, already 7 months.
R. Fukan, learned counsel for the petitioner who has alleged willful and deliberate disobedience of the order dated 6/12/2024 passed in WPC 6239 of 2023. Full stop. A perusal of the order dated of the aforesaid order will, however, show that no mandamus as such was issued. Full stop. However, there was an observation giving liberty to the petitioner to file application, and if such application is filed, to examine the same in accordance with law. Para? Be that as it may, comma, let notice be issued, returnable by 6 weeks. Baki khini hai, huh? Registered post 2 days of last. Item 9, yes.
May I please, Your Honor?
Yes, Mr. Mazumdar.
Lordship, in this case, there is a dispute with regards to the apportionment and entitlement of the Jirat and compensation.
Affidavit filed.
No, Lordship. Motion said, Lordship, may I,
There are certain affidavit. What is the affidavit?
Lordship, is that I have filed
Additional affidavit.
additional. affidavit.
No additional affidavit.
Lordship.
Why?
Lordship, by filing one additional affidavit, petitioner Bingon records the judgment of the learned trial court. A suit preferred by the present petitioner against the private respondent number 6, thereby claiming his right over the disputed land. His occupancy right, the suit was dismissed, against which he preferred appeal. Appeal allowed, appellate court reversed the judgment.
Yes, what do you say? He had approached the civil court, then there was an appeal also.
Lordship. And against that appellate order, private respondent preferred a second appeal before this honorable court. Lordship, may I draw your Lordship kind attention to 3H of the highway national.
No, those are
highway
okay,
code?
but aren't this subject matter covered by the appeal which is presently in this court? It's a dispute between you and the private respondent.
Lordship, that's why I'm praying. Lordship,
Regarding
may-
the Jirat amount, Lord.
It will be decided in the civil court.
Yes.
Lordship,
It has
that-
reached this high court in the
Lordship, that
civil appellate jurisdiction.
PH4.
that is the Lordship kindly 3H4 of the national highway.
National Highway.
A direction may be issued and writ petition may be disposed of
Direction for what?
for referring before the civil court, Lordship, under 3/4 H of the.
Then what is the subject matter of the appeal?
uh,
Presently in this court.
Lordship, till date it was not referred, though we have filed.
Now, what is the subject matter of the appeal? You have said that the private respondent has filed preferred an appeal in this.
Subject matter challenging the Lordship appellate judgment by which Suit of the plaintiff was decreed.
Now, who are the respondents here?
Lordship.
Has, in the meantime, has the respondent number 6 appeared in this matter?
No. Lordship.
Notice is yet to be
Not
issued.
issued.
Without issuing notice.
Lordship.
And don't you think that there will be overlapping of the subject matter in entertaining this petition? Same subject matter.
His main claim is not regarding the amount of the landlordship.
Well,
Is
it's a apportionment
Zirat.
issue on the
Yes,
apportion.
apportionment of the Zirat amount.
And the appeal is what? The subject matter of the civil suit was what?
It is for the Lordship, I have claimed occupancy right over the disputed land. But the private respondent number 6 dispossessed me. That's which was.
So ultimately, the
Yes.
interest is on the compensation amount. How much you will get, maybe as an occupancy tenant,
Lordship.
how much she will get as the landlord. And that aspect itself is a disputed question.
Lordship, that Lordship may, Lordship
Heard,
direct the authority to refer before the civil court, Lordship, under section 3H, 3(4) of the Highway
heard
Act.
Sri L.R. Mazumdar, learned counsel for the petitioner. Full stop. The grievance of the petitioner is in connection with the compensation for acquisition of land by the National Highway Authority
Yes.
for in connection with the Okhomala. Which project? Athamala?
No, Lordship, it is.
Bharatmala.
Bharatmala.
Yes.
Bharatmala in the district of Kachar. Full stop. It also transpires that the petitioner had instituted a title suit 84 of 2009, which was decreed on 31/5/2016, and the suit was dismissed, whereafter the petitioner had preferred title appeal 34 of 2016, which was allowed by judgment dated 9/2/2021. It is also submitted that the private respondent number 6 has thereafter preferred a second appeal being RSA 27 of 2022, which is pending in this court. The learned counsel has submitted that the present cause of action is with regard to the apportionment of the compensation. Let notice be issued, returnable by 6 weeks. Madam, you form 1, 2, 1, 2. 1, 1. Oh, what about 1 will appear? Arbora, 1 and 5. Madam, your name? Miss L. Gogo on behalf of C. Bora for respondent number 2. And 3, 4.
3/4 Lords.
3, 4 H. Sharma, edition senior accounting. Let extra copies be served. 6 registered post with AD. The maintainability of this writ petition is, however, kept open. Yeah, respondent number 6 may say something else without hearing. Let us not say anything. Okay, next.
Lordship,
Interim of what
Lordship,
nature?
during pendency of this petition, may not disperse the compensation in favor of the private respondent.
From March, this writ petition is being heard on at least 4 occasions. There is no
Lordship,
interim order.
Lordship, earlier some of the documents.
Any action taken towards disbursement of the compensation amount shall be subject to further orders that may be passed.
Like,
Yes, Mr. Satar.
Please, your lordship. My lord, lordship, we have been directed to obtain instructions, lordship, we have not received any.
What is the matter about?
The matter is about the construction of a building, my lord, which was allowed by the Boganga Municipal Board and G+4 construction, my lord, G+4. My lord, all of a sudden, it was stopped by the additional district magistrate, my lord. That is by order dated 12/3, my lord, 12/3/2025, annexure 16 at page number 119, my lord. On 25.
But you have already demolished on your own and a re-permission was given to.
Yes, my lord.
Now you are aggrieved by what?
I am by
the initial action.
Order dated 12/3, my lord.
Initial action.
No, not initial action.
What is 12/3?
Subsequent. It is at page number 119, my lord.
Okay, the new construction, there is also a restraint. Mr.
Temporary
Sattar,
suspension
Yes,
of
we have seen
construction
this.
activities,
There is also a restraint on the new construction.
not new, my lord.
After the demolition of
After the demolition of.
Yes.
Yes,
fresh construction.
yes.
Okay. Heard 3A Sattar Learned Counsel for the petitioner. Full stop. The grievance of the petitioner is against an order dated 12/3/2025 issued by the Additional District Magistrate Bongaigaon directing the petitioner to stop construction till a resolution is taken. Full stop. It is averred that the earlier construction of the petitioner was objected to by the respondent number 8,
Yes, my lord.
and after an inquiry, the petitioner was directed to demolish the said construction which was accordingly done. It is also the case of the petitioner that thereafter he was permitted to start the construction afresh by an order dated 20/2/2025. Correct?
Yes, my lord. My lord.
Let notice be issued, returnable by 6 weeks. Yes, so what is this? Respond number 1.
Respondent of municipal board, my lord.
1. Respond number 1.
State of Assam, my lord.
Represented by whom?
Represented by the district magistrate.
District Minister represent the state.
My lord.
Don't
My
make this kind of elementary, not from you. How is the district magistrate representing the state? There are departments.
Department is there, my lord.
Why
Here-
this kind of things?
Here, administration and magistrate branch.
Whatever is it, it's a DC office. DC is a different, it's not the state.
Of course, my
State
lord.
will be represented by the secretary, additional secretary, deputy secretary.
True, my lord. True, my lord.
Departments are there.
True.
1, yes, you can take 1, I think. 1.
Only one.
What about Bongaigaon Municipal Board? Do you have a standing council or do you take instruction?
Bongaigaon Municipal Board, lordship, most probably they do not have the notice have to.
Mr. Sattar, what do you do about respond number 2, 2 and 3?
Respondent number 2, my lord, on the last date, my lord, is, when the order of 25/7/2025 was passed, simply it was directed to take instruction regarding the power.
You have to take steps. 1 is by Sharma, then PWD, anybody is there? PWD, Mr. Chaudhary, Mr. Borwa? On behalf of Mr. Chaudhary? H. Borwa, on behalf of B. Chaudhary. 4. What is this? EO means what? EO, Bongaigaon Municipality?
Executive officer, Boganga Municipality, my lord.
You can't even write EO, Executive Officer.
My lord, actually, the designation which is signed by them is EO,
But EO is a cost title.
Enquiry Officer, my lord.
Cost title.
I will rectify that.
How will it go?
Well,
Will it go like this? EO Bongaigaon Municipality by registered post PTT?
Alright.
My lord, they have.
What is
signed it.
who is for the assistant director? TNCP.
My lord, if your lordship pleases to pay.
I think you can take town and country planning, or is it by somebody else? 6.
Town and country planning we can. Town and country में होगा ना? Yes, Lordship.
Yes, 7 exit.
Yes, Lordship, 6, 7.
7. Then Sharma for 1,
6 and 7.
1, 6 and 7. 4 is by H. Borwa and rest registered post-petity. That's written to this. Extra copy.
My lord, may I pray your lordship that the order dated 12/3/2025 be suspended.
That will be amounting to giving you a final relief. If you construct in the meantime, what will remain? You take instruction, Mr. Sharma.
Lordship, Lordship.
Why did you stop construction?
Please, your lordship.
My lord, Mr. B. Gogoi is appearing in this matter, my lord. He's on legs in another court, my lord.
11.
11, my lord.
What is it, Mr. Mishra?
I am carrying a so-called notice, my lord, whereby my lord, my GST has been
Is it
suspended.
covered?
Not covered, my lord, different.
Show cause notice.
Has been my lord, whereby
Suspended. Why have we come to the writ code? Why don't you show cause?
the so-called notice did not give any particulars. It's a vague one. Your lordship makes see page at 19. They have come up with number of allegations in the affidavit, my lord, but this is not a part of the so-called notice. Simply they issue one page so-called notice saying that you received ITC from non-existent GST. Which is the non-existent GST? Nothing is mentioned, my lord. They have filed an affidavit, my lord, wherein they have made
Yes,
certain-
we have dealt with this matter on 37.
Yeah.
That was the contention that there was no specific allegation.
Nothing. I have judgment of the other high courts, which says, my lord, in the absence of my lord, allegations of my lord, particulars,
How
one-
will they file a reply if you do not give him the particulars?
There
He
is
will
one
not
more
file
thing.
reply on the basis of an affidavit.
And there
He
is-
has to file a reply on the basis of the allegations made in the show cause.
And there is one more thing, my lord.
Mr. Chaudhary would come.
B. Gogoi, my lord.
D. Gogoi, withdraw this and file of you. Is there any enclosures to the show cause?
Nothing, my lord. Only
Nothing.
one page. Lordship may say 19 is a one-page notice. Nothing is there.
You can withdraw this. You have to give him a fair chance. What is the what is the objective? Just to give him a fair chance to maintain transparency, fairness.
My lord, let him appear in this matter, my lord.
Okay, today?
Today, my lord.
Okay, after a while,
My
Mr.
lord.
Why don't we have
My lord, even in this matter, my lord, since Mr. B. Gogoi is appearing, my lord.
possible for time being lordship?
What is the subject matter?
The possible for time being, Dr. BP to do the appear lordship. This is in court number.
It's a eager matter, my lord.
Okay.
Lordship, the petitioners have approached this honorable court previously also, your lordship, and an order was passed. This is regarding land acquisition, your lordship.
Hmm.
So their land was being disturbed without any process of law. There was a direction on the motion, it was disposed of, that if their land is acquired, proper process has to be followed. Thereafter, for 1 year, there was no disturbance, your lordship. Recently, they have again started to fill up the land, and in the meantime, fence has been destroyed, your lordship.
Yes,
I'll take the instruction.
heard. Shri B.J. Mukherjee, Learned Counsel, for the petitioners who are aggrieved by the action of the respondent authorities in disturbing their peaceful possession over the plot of land in connection with the Assam Mala project. Full stop. The Learned Counsel has submitted that without initiating any acquisition proceeding, such disturbance was earlier there when the petitioners had approached this court by filing WPC 6130 of 2023, in which an order dated 16/10/2023 was passed by this court directing that no action be taken without following the due process of law. Full stop. It is submitted that for a period of about 1 year, there was no disturbance, which however has resurfaced recently, and the fencing of the plot of land of the petitioner has been damaged.
Damaged.
let notice be issued, returnable by 4 weeks. Revenue, PR Mohanto, Miss PR Mohanto 1, BTC Chaudhary, BTC 2,
2, 4 and 5 lot.
2, 4 and 5.
3 and 3, my lord.
Oh, circle officer, you can take.
Yes.
Okay. And but and
Three.
that's for 3 and
Three only, my lord.
3. Extra copies. 3. Mukherjee, praise for an interim order. Para. After hearing and taking into consideration the earlier directions passed by this court, it is provided that the peaceful possession of the petitioners over the plot of land in question is not to be disturbed without following the due process of law. You bring the whatever is the document
Yes, yes.
notification. I'd like to
Yes.
see the notification. Yes, next.
May I plead your lordship? Lordship, matter regarding inaction of respondent number 2, my lord, regarding issuance of sale permission or no objection certificate. My application is my lord, page 24, my lord, and check sheet.
Heard Miss Al Wazida,
My lord.
learned counsel for the petitioners who are aggrieved by the inaction of the respondent authorities in issuance of the no objection certificate for sale of land. Full stop. Let notice be issued, returnable by 4 weeks. 3. Miss Mohanto, PR Mohanto 1,
2, 3, my lord.
1, and thus State Council 2 and 3. Then 4, 5, 6, 4 to 10. Restart posted AD.
Oblige your lordship.
And there are in
Extra
5
copies.
there are 4 legal errors. You have to give it separately. Okay.
Extra
Steps,
copies.
steps it into extra copies, steps it into working this. Yes.
Very pleased, your lordship. This case, my lord, the non-furnishing of the certain documents were submitted at the time of selling loan by the younger brother of the petitioner who was expired in the 2019, my lord. So, my lord,
Non-furnishing of
page 25, my lord. What happened in this case, my lord? The younger brother of petitioner, Rajiv Kumar Sharma, he availed loan of rupees 2,80,000 in the year
from
19
whom? From whom?
from the Assam Financial Corporation. He expired in 2018, my lord. The present petitioner being elder brother, my lord, he settled the full amount with the corporation at rupees 31 lakhs.
Where is the corporation party?
Assam Financial Corporation, my lord.
Party? Which one?
Revenue, some is the selling.
Managing Director, Assam Financial Corporation.
Where?
My lord.
The managing director. Where is the corporation a party?
The chairman of the Financial Corporation.
Where is the corporation a party? You are making the chairman, you are making the managing director a party. We need the corporation as a party, the legal entity. Where?
At other made by my lord, actually.
If you don't make the entity a party, how do you get the relief against whom?
Because entire communication is made with
Who
made
is
with
going to make the communication? You have to make the entity a party.
AFC represented by.
Yes, but
You know
actually-
how to do. You know how to do. You are not supposed to be.
Yes,
Not
my-
in the court. You don't make the legal entity a party. You make some officers of the entity a party. Make the entity a party.
Yes, that has been made, I'm sorry.
You make it a party. And first respondent, you write like this. Principal Secretary of the Assam Finance Department. What is this kind of?
It is undertaking of this Assam
No,
Financial
first
Corporation.
one, the
Yes, first
Principal
yes,
Secretary of Assam Finance Department, you write some Assam Finance Department. First respondent. What is Assam Finance Department? You know, there is a process,
I'm sorry, I'm extremely
manner, how to make parties.
sorry.
You
I'm extremely sorry.
don't, you use this kind of expression. You make the finance department a party, state of Assam, representative of finance department, the secretary is there, commissioner is there. What is this principal secretary of Assam finance department?
No, extremely sorry, it is absolutely.
You make this entity a party,
It's fine.
Assam, because your main grievance is against the corporation.
Corporation.
Okay?
My prayer is very simple, my lord, against.
On the prayer of Sri F.K.R. Ahmed, the matter is adjourned by a week to enable him to file appropriate application for impediment of necessary parties.
Okay.
And I think AFC has got a standing counsel. You can serve them.
Remaining.
Okay, next. Please.
Item 17.
Yes,
It's a covered matter, lordship, just to cancellation. Not covered, lordship,
yes, order.
not really allowing. lordship.
We'll record his submission last date that is not covered. He has no explanation. Not covered why?
Lordship, their contention is that the registration was cancelled. So, it was cancelled for non-filing of
Return.
petition. That is reflected. They said that it is not reflecting the cancellation order. But lordship.
Okay. Yes, covered code. Dispose of.
Obligation.
Make the corrections and show it to Mr. K.
Yes, I have seen.
Mr. Das.
Well, in this case, my lord, government, see, petitioner before this honorable court, my lord, is a GP member, elected member, number 6 simultaneously village, my lord. And of the particular, my lord, government, here what is happened, my lord, first meeting was held, my lord, on 7, my lord, 9, 11, and thereafter 19 also, my lord. But on 7, as there was no, my lord, lordship, page, my lord, that is, vote taking meeting and selection of the the president, vice president, etc. Page 22 and except 3.
Now, if somebody is not attending the meetings for 3 occasions, who will take the decision to disqualify?
Yes, ma'am.
Who will take?
My lord, it is the authority, my lord.
Which authority?
At present, my lord, my first grievance is, my lord, for my lord, second meeting legally held, my lord. It has to be, my lord, held as a, my lord, quorum was in the first meeting, if no quorum is not formed, my lord. In the second meeting, it has become the, my lord, valid meeting, my lord.
So what do you pray in this petition? What is the relief?
Yes, my lord. My prayer is, my lord, the meeting dated 9/7 is a valid meeting, my lord. It has to be held as a valid select for vote taking meeting and also, my lord, first meeting for selection
How
of the
many of you are there?
lordship.
How many of you are there? 1.
Yes, my lord, six GP members were there.
Petitioner, is it 1?
Only one petitioner.
And how many respondents?
Respondents, my lord,
1,
here
2, 3, 4, 5.
up to 10.
No, private respondents.
Private respondent, my lord, 7 to 10, my lord.
No, 6 to 10, not 7 to 10.
Oh, yes, 6 to 10. They were actually, my lord, my grievance was, my lord, against them, but they did not appear, my lord, in the meeting, first meeting, second meeting, third meeting.
We don't think you have a case here, but nonetheless. Third, Sri H. Das, learned counsel for the petitioner, who, petitioner, it is projected that the petitioner has been elected as a member of the so-and-so Gao Panchayat from village number 6, Simul Kandi, in the district of Gwalpara. Full stop. the petitioner contends that there has been there have been 3 consecutive meetings, and yet no oath could be taken. Full stop. As per the petitioner, the meeting dated 9/7/2025 should be
Yes.
treated as a valid
Valid
meeting.
meeting.
Para? Let notice be issued, returnable by 4 weeks, 6 weeks. Ms. P. Thapa P. Thapa on behalf of S. Datta for 1,
And 5.
1 and 5. District Commissioner and us,
2, 3.
2, 3, 4.
4, my lord, assistant commissioner. Assistant commissioner, what, my lord?
2, 3, 4. Then 6 to 10, restart post-TD. Extra copies and steps within 2 working days.
Right.
Okay.
The petitioner have been elected as a panchayat member. And when the first meeting was scheduled to be held on 8th of July, but it was postponed to 9th. But grievance of the petitioner is that in that meeting, the notice was not served to them. And accordingly, they filed representation before the deputy commissioner also.
How many of you are there?
4 numbers of petitioners. This is the grievance, but no notice. And on 9th of July.
Why notice you were there on 8th when it was deferred
No,
to 9th?
8th, it was postponed.
Postponed?
And notice was issued on 7th. And even that subsequent notice we did not receive.
No, were you aware about the 7th meeting?
No,
The-
no. That
The notice of 7th.
notice of 7 also we are not aware. That is the case. And as provided under section 46, notice is required to be.
Part 3N of Learned Counsel for the petitioners. Full stop. As per the projected case, the petitioners are elected members of the number 46, Pampara, Chatalpara, Gaon Panchayat in the district of Dhubri. And their grievance is against the first meeting, which has been held on 9/7/2025. Full stop. It is contended that the statutory requirement of giving a notice with 7 days clearance time has not been followed, and the petitioners, as a result of which the petitioners could not attend the first meeting. Para, let notice be issued, returnable by 6 weeks. 3 PNRD Pithapa 1,
4 and 5.
1, 4, and 5. Then District Commissioner and us 2,
2, 3, my lord.
2, 3. Then Secretary, also you've taken, okay. As okay, extra copies. Then 6, 7, 8, 9, 10, 11. We start posted ready. Steps within 2 days, 2 working days.
Oblong.
2 days leave হলে হবে, তাই তো continue হবে। Friday হলে 2 working days হবে।
May it please your lordship. Initially, what started as a dispute between 2 neighbors. Later on, the chairman of the board, Miller, he apparently was seen taking.
Is there a standing council of the municipal corporation?
Yes, we have served copies.
Adhor.
We have served copies.
Where is he?
Reflected. I do not know actually where it is. What we are praying is that their page 105 is the order impugned. And prior to that, notice and contempt was also issued, contempt petition, which is substantiated by this order at page 105. It runs a couple of pages, but in substance, it affirms that.
When did you file the complaint?
We had filed a complaint because
When?
Initial complaint.
No, the one which is the subject matter of this petition that you want
My lord,
consideration.
41023 at page 84, if lordship takes up the 84, there's an observation by the honorable court saying that it took over a year for the chairman to keep it pending and not take a decision. Therefore, a direction was passed by this honorable court giving a fixed timeline, what is to be done. Subsequent thereto, the political bigwigs were called, we came to the writ petition, there was an order affirming that, and that was set aside. And now when it is called, the pressure is being asked to go for settlement or withdraw. Then we had filed a complaint petition, a contempt petition, and notice was issued. Now at 105, they affirmed that yes, there was a move to have it compromised. We did not give it, but
Can you get Mr. Dhar?
certainly, Miller.
We'll try to,
We are praying that let both the parties
let Mr. Dhar come,
Gotcha.
his,
oblige
after a while.
after.
In short manner, the land was allotted and it was cancelled without giving any notice. Land belonged to the petitioner's family. So I'll be praying for a notice, my lord, and the lordship will kindly see page 18.
When was it allotted?
It was allotted on, my lord,
11/2.
yes, 11/2. It's a family land, my lord. It was given to a memorial. The memorial did not utilize it. So we filed a petition for allotment of the land to us. Now we are saying, my lord, they have cancelled it only for the purpose of giving it to some persons who will be benefiting from National Highway, my lord, that acquisition project.
But it was done by allotting, by cancelling the allotment made earlier
No, it was, that land
to the
belongs to
Memorial
me.
Trust.
The memorial trust did not utilize it because it belongs to our family. Your
Part
lordship will
3
kindly-
Bididas Learned Senior Counsel, assisted by Ms. R. Deka, for the petitioner. The grievance of the petitioner is the cancellation of an allotment of land which was made in his favor by an order dated 11/2/2025. Full stop. It is the case of the petitioner that pursuant to the earlier order dated 11/2/2025, he had taken possession of the land and had also deposited certain amount towards settlement fee. Full stop. However, by the impugned order dated
22/25.
20/2/2025, the same had the all order of allotment has been cancelled. That notice be issued, returnable by 6 weeks, 3,000.
Lordship.
Learned Standing Council NCHAC accepts notice on behalf of all the respondents.
Respondents also.
That extra copies be served upon him by tomorrow. You have not made this memorial a party trust.
Memorial is not necessary. Memorial is in our favor on that. If necessary, I'll make
You
it.
should
my
make
lord.
him, because that is the reason. I
I'll
think you
make
should file an amended.
My lord,
replacement application. Yes,
My
next.
lord, status quo in regard to the land.
Lordship, this settlement, this cancellation has been made because there is some dispute. And it is, a complaint has been received, verbal complaint has been received by the authority.
Till
Lordship.
returnable that status.
That party is not before us. Difficult.
No, your lordship will kindly see, my lord.
Yeah, make the party respondent will see.
Yes, I'll do.
Sri Das, the Learned Senior Counsel, prays for and is granted liberty to file appropriate implement application. Yes, next.
Obliged, Lordship.
Oblige.
My lord, the petitioner's land was taken, my lord, for public purpose, my lord, for establishing Majuli Culture University, my lord, with the promise that they will give us an alternative land nearby and without any compensation, my lord. But he filed representation, my lord, 3 representations, but nothing has been considered, my lord.
Your land has been acquired.
Acquired, my lord.
By what?
I don't know, my lord, but that it appears that they have acquired with the promise that they will give an alternative land nearby, my lord.
No, the acquisition was under what act?
Under Land Acquisition Act, my lord.
Where are the
But
papers?
I don't have any papers, my lord, but the only thing is that at this stage, I pray that, my lord. My representation to be disposed of.
Under what authority, Lordship, this land is
Will
acquired?
let me notice be issued then, my lord.
Now, where are your agreements
Uh,
regarding the taking away of your land?
Yes, I've lordship may see, my lord. Para, my lord. Para 4, my lord. That is stated in the year 2022, the said plot of land was acquired by Majuli Revenue Circle for the purpose of establishing the Majuli Cultural University and academic and cultural institution and the government of India, Assam. It is pertinent to mention here that at the time of acquisition, government authorities, that is respondent number 2, 3, and 4, have assured the petitioner and his brothers recorded pattadas that instead
I
of
think you should have given more particulars of the
I
acquisition
know.
proceeding.
So
Art 3, J. Roy Leonard Senior Counsel for the petitioners whose grievance is against a purported acquisition proceeding of the year 2022 by which it has been by which the land of the petitioner has been acquired for establishing the Majuli Cultural University. First up, it is submitted that till date no compensation has been paid and further
for compensation, my lord, for alternative.
and further that no alternative plot of land has been provided. Para. The petition, however, has not disclosed any details of the acquisition proceeding, nor any documents towards the same has been annexed. Para. Be that as it may, let notice be issued returnable by 6 weeks. Pre H. Sharma, Learned State Council, Learned Additional Senior Advocate. One is Piermont, one Piermont. 2, 3, 4, H. Sharma. Okay.
Lordship.
Extra copies within 2 days.
My lord, oblige, my lord.
Maybe 3 years.
Yeah, Lordship. Lordship, my senior on lakes in another court, Lordship. Can the matter may be fixed after some time, Lordship?
What is this matter?
The police harassment, they are asking for under what authority or under what case they have been harassed, but Lordship, nothing has been provided to them. This is the case, Lord. So violation of fundamental rights.
Okay. What is your name, madam?
P. Boro, Lordship.
P. Boro.
P. Boro.
Hard. Let's P. Boro Learned Counsel for the petitioner who is aggrieved by the who is aggrieved by the harassment made to him by the police. Full stop. The petitioner also claims that the representation has been submitted to the Superintendent of Police Dhemaji, which however has not been acted upon. Para.
Let me get the instruction, Lord, from Dhemaji.
Is there any police case?
No, Lordship, they are asking for, that was not provided to them, and Lordship, they are, that is the allegation, and by name also, Lordship, they have made parties.
There would be something. Let notice be issued, returnable by 6 weeks. Three H. Sharma Learned Edition Senior.
1 to 4.
1, 2, 3, and 4. Let steps be taken. Extra copies. 5 and 6 were listed post with AD.
Extra copy.
Post of 3. Sharma, the London State Council is directed to obtain instructions by the next date, if any case is
Lordship.
pending, filed pending against the petitioner. Pending against the petitioner. Okay.
Lordship, my lord, here are petitioners before Lordship, my lord. They were allotted certain plot of lands, 2 katha or 3 kathas of land for their dwelling house.
Yes.
A number of persons have been provided patras. That patras they have annexed,
Yes.
that Lordship may kindly see page 28 onwards. But we have been given the land allotment certificates, patra has not been provided. So we are in apprehension that any time we may be disturbed. So similarly situated persons have been provided patras.
Partners are provided under what provision of law?
That is under the provisions of Assam Land and Revenue Regulation.
No, that is not an answer. Under which specific provision? What is the method?
Yes, my lord, that is rule regulation 8.
Regulation
It
8.
is regulation 8.
Yes.
After praising the report and map and making such further investigation as may seem necessary and settling any dispute that may have arisen.
You're reading which regulation? Of what? Of
1888.
1886.
1886, yes.
Which regulation number?
Regulation number 8.
Please read. Status of landholder, how required?
Yes. After Lordship, this is the page 78. Page 78, 79.
Now, what is the name of the, you're reading the, are you reading the regulations of Assam Land and Revenue Regulations?
Yes.
Regulation 8, please read what is the title of the regulation? The section 8, regulation 8?
No, rule 8. Rule. Sorry, I'm saying. Rule.
Yes.
Rule 8. So those were done, investigation were done, and we were found landless and land eroded men. Accordingly, the government prepared a list and a number of persons have been provided patras, and we are applicants among those persons. But we the three have not been provided. Others have been provided. I have already annexed those patras. Namdari.
Yes, we should notice.
My lord, also, for a minute, my lord, page 82, my lord. 28, my lord.
28. Yes.
Here, my lord, Abdul Aziz, son of Monaf Ali. My lord, and if your lordship come to this allotment, my lord, it is shown as a Juran Ali, my lord.
Where is the allotment?
Allotment, page 19, my lord.
19.
19. And cost title also, my lord, it is shown as Juran Ali.
No, this we are not the Juran Ali. We are here three persons. That is Lordship Shamiran Nisa, Abdul Aziz.
I'm saying about Abdul Aziz, my lord. There is so much contrary, my lord, in cost title to allotment to the Jamabandi, my lord.
No, that may be investigated. If there is some wrong or foul place, that may be investigated. But for that, my lord, when we have been provided certificates, so this government cannot go there against their own stand. Kindly see page 15, madam.
Now let me bring my instruction.
Heard Sri M.U. Mahmood, learned counsel for the petitioners. Full stop. It is projected that the petitioners were allotted.
One second, my lord. I am sorry, I am pained. Kindly see page 15.
Page 15. Now we are issuing notice at this stage.
But may not be disturbed. That because others have been provided.
No, my lord, stay, I'll be opposing, my lord.
Oh?
Stay, I'll be opposing, my lord.
By their.
Because bona fide, he has not able to show my.
Is there anything, any notice given to you?
No, notice is not given, but from surrounding area sounds are coming. Lord, kindly bear with me. This is their lapses. They have issued, allotted the lands. Some persons have been provided patras, some are not.
That we have understood, but where is the apprehension? Apprehension is based on what?
I don't know pleadings also.
Where have you stated that you are about to be evicted?
My lord.
Yes.
There must be some apprehension.
No, apprehension is.
There is not even bona fide also, my lord.
Well, you should notice at this stage. Heard Sri, I mean, Mahmood, learned counsel for the petitioner. কি করবে? Were allotted certain lands. Full stop.
Lordship, kindly see page 12,
Where?
para 15.
Para 15.
15, page 12.
Yes, please.
That the petitioner requested that those similarly situated persons have been granted pata, but the authority ignoring the claims of the petitioners, they are in dilemma that the government of Assam may evict them because the government is evicting various persons at randomly without considering their hardship. So this is our apprehension.
Allotted certain lands. Full stop. It is also averred that while similarly situated persons who were allotted land were subsequently granted patta, the same has not been done so far as the petitioners are concerned. Full stop. The petitioner also apprehends eviction from the land allotted to them. Sarah, let notice be issued, returnable by returnable date. We'll give a returnable date. Returnable on today.
Other case 6 weeks, mail.
No, we'll give an early date. Returnable on 26th of August. And thus, Learned State Council accept notice on behalf of all the respondents.
2, 3, 4, mail.
Okay, one is Revenue Department, and G has a record. And 2, 3, 4 State Council. Extra copies by tomorrow. Sri Mahmood, the Learned Council, praised for an interim order. Para, considering the facts and circumstances. Where are the allotment orders?
Allotment order, Lordship.
My lord,
Page
regarding
15.
interim, let it be on, my lord, next that. Or
One-
either it will be on 2 weeks, I'll bring the instruction, my lord.
1-5.
Because bona fide, he is not able to prove anything. All mismatched, my lord.
Surprised, my lord.
Son of Juran Ali.
My lord, I am
Son-
surprised because government has allotted the land after verification.
That
After
is
examination of
your
government-
submission.
You
Let
cannot-
the
you
facts
cannot
come.
take
I have got
different
every-
decision.
I got every
Your-
right to make
No,
an
no, you have
objection.
no right, because your officer has done.
I have got every right to make an
No, you
objection.
have no right, because you have
Let
already
it,
allotted.
let it on 2 weeks, my lord.
Please
Allotment is
address
not-
the court. You're supposed to address the court. You're not supposed to address your counterparts.
My lord, my humble prayer
It is this court which will govern and control. Don't make this into a fish market. We are not used to this kind of behavior in the court.
I understand that.
Both to you, Mr. Mahmood and Mr. Das. There is no occasion to look at him and for you to look at him. Any grievance addressed to the court, we'll look into it. Maintain minimum decorum. We don't appreciate this kind of conduct by the council. What is there so serious? Is it a personal dispute?
Sorry, my.
Go outside and fight. Not in the court.
My lord, my only prayer is.
We have considered, yes, returnable place for an interim order. The aforesaid prayer has, however, been objected to by the Learned State Council by submitting that there are discrepancies in the land document, and for instance, he has pointed out that so far as the petition number 2 is concerned, the name of the father is not matching. But after considering the facts and circumstances, this court is of the opinion that till the returnable date, an interim protection would be towards the interest of justice. Para, accordingly, till the next date fixed. That is, we have given a date 26th of so status quo with regard to the possession of land be maintained. Para, since the interim order has been passed at the motion stage, the same would be reconsidered after obtaining of instructions by the Learned State Council.
Can it be after 2 weeks?
My lord, one point.
Can
my
have
lord,
it
here.
if you can bring it.
Page
on
19.
On 18th.
My father's name is there.
18th. But you give copies today itself.
Yes, today.
Returnable 18th. Yes, item 11, Mr.
Here I'm telling you the so cause notice, my lord.
Mr. Gogoi. Mr. Gogoi, your show cause notice has not disclosed anything.
But they only say, there's certain transaction,
Now, how does he submit his show cause? Not on
But-
the basis of your affidavit.
But my lord, one thing, after the so cause, he has already responded. If he has not understood, he would not have responded. Lordship may kindly see, my lord,
Let us see the response.
yes, no.
Page
Page
Lordship
20.
will find page 20.
20.
Yes, sir.
Yes,
The Lordship will see the reference, my lord. First one itself is the so cause.
yes.
So we are to, my lord, take a call on this particular
Lordship,
reply.
their affidavit, page 51, paragraph.
Just a minute, just one by one.
From page
20 is the
20,
show cause.
yes,
show
reference
cause.
so cause dated
Yes.
11/7/2025, which is impugned here.
Yes,
So now here, my lord, they have referred to certain, my lord. In fact, my lord, their transactions, my lord, page 21, SM traders.
yes. SM traders. Yes.
So they have, my lord, in this particular reply, they have adhered to all the, my lord, means, my lord, to justify their stand. Lordship will see, my lord, various headings, my lord, violation of natural justice, request for revocation, assurance.
Yes, if you
All of-
understood
Yes,
the
yes,
contents.
yes, my lord, moment they
No,
are-
Mr. Mishra,
My lord.
there is nothing to dispute with your submission. We are with you that the show cause notice is not having the particulars. But that is a factual averment. Your reply shows that you have understood the meaning of the show cause. You have replied.
I'm coming, my lord. What
If you
happened?
go to substantial justice, is there a violation of your rights? You should have said that we do not know whether the
I'm
allegations.
coming, my lord.
Yes.
What they are admitting, my lord. We went to the office and we requested that nothing is mentioned, why you have suspended. Then verbally they are saying, they admitted, my lord, that these are things, my lord. Verbally, my lord. They are admitting in the affidavit, my lord, verbally they have said, these things are there, you have not complied, my lord. Now, my lord, on verbal things, can the order be passed, my lord? Because if this is the requirement, my
Mr.
lord.
Gogoi, why don't you make it straight? Withdraw this and file, give another show cause notice. There is no restriction on your part.
Yes, otherwise,
Ultimately, it has to be transparent. You are right in contending that he understood.
my lord.
But we cannot
Yes, yes.
ignore or overlook his submissions that it is on verbal communication.
But can it be a 2 months? Thus, I will have the telephonic instruction. So motor will withdraw it, my lord. Instead of-
And you,
Better-
you'll be at all your liberty to
That,
proceed.
my lord, Lordship
We
will
are not,
definitely grant us.
we are not even saying, we're making any observation,
Lordship, that will
but
be-
do it in accordance with law at 2 o'clock.
My lord. Obliged, my lord.
Yes, taxes, what is this?
Maybe you see, my lord, this is a case, my lord, where, my lord, in fact, my lord, in 2014, some search and seizure was made in violation of the, my lord,
When, 2014?
my lord, some search and seizure was made, my lord, by violating the provision of section 74 of the Assam Value Tax Act, my lord, which is repealed, my lord, then, my lord, GST came in. So, my lord, what I meant, my lord, as against the illegal search and seizure, my lord, the petitioner approached the Honorable High Court, and, my lord, the learned single judge, my lord, passed the order, which you will find at page 85. It starts from page 85.
85,
Yes, page 85, my lord. It starts, my lord, judgment.
yes.
Date of judgment was the 5th November 2019, my lord. My lord,
You are one of the petitioners here.
yes, my lord.
5/11/19 order.
May I read, my lord? My lord, it starts from page 87, my lord.
Yes.
May I read, my lord? And then appeared for the petitioner, though none has appeared, the petitioner concerning nature of the issue involved in this petition, the grievance raised by the petitioner and the relief rate court. This court is of the view that these writ petitions can be disposed of on the basis of the pleadings made in the writ petitions. In this writ petition, the petitioner found
You can come to the operative part. This is the
my lord,
8-page
my
order.
lord,
we should-
operative part also may kindly
Page
come to you.
92.
Page 92, my lord.
Yes.
in the para 8, my lord, in the present case, the respondent authorities were empowered by the provisions of the special enactment, namely the Assam Value Rate Tax Act 2003, to conduct search and seizure of documents and goods, but they have to follow the procedure laid down under section 47 and section 100 of CRPC and the provisions referred to the depending upon the nature of investigation. Be that as it may, since the search and seizure of documents as mentioned above were effected way back on 3rd September 2014, this court is of the view that it may not be necessary to make any further observation except to hold that if any cause of action still survives, the petitioner will be at liberty to approach this appropriate forum with the period closed with the above observations. What happened, my lord, during the pendency of the, my lord, the petition before the honorable court, my lord, the respondent, what they did, my lord, they made the assessment and issued the demand notice. So, my lord, by then the petitioner what they did, my lord. So they again, my lord, filed IA, my lord, which will lordship find at page 96, my lord. My lord, page 96 and the operative part, it is lordship will find at page 98. May I read, my lord? The said petitions was disposed of in absence of the counsel of the petitioner as non-appear to the petitioner on that day. However, this court referring to the affidavit position filed by the respondent did not go into the correctness of the impugned search and seizure, but made the observation that the provisions of CRPC ought to have been scrupulously adhered to at the time of effecting search and seizure. Then, my lord, next para, since the search and seizure of documents were effected way back, so, my lord, this court did not make any finding, but as regard to the validity of this search and seizure challenged the petitioner, but made an observation that if any cause of action still survives, the petitioner would be at liberty to approach the appropriate forum. It has been stated that after disposal of the said petition, on 5th.
We have read this, come to paragraph 9.
9, my lord.
Yes.
This court of my lord. My lord, I was just giving a background, my lord.
No,
Anyway,
background we have already seen.
My lord, my lord. Para 9. This court is of the view that since the aforesaid petition so and so already disposed, it would be more appropriate for the applicant to challenge the said demand notice before the appropriate forum. However, not by way of interpreted application to the already disposed to the petition as sought for done herein. As the whether the petition of the appeal is the appropriate forum, it may not be necessary for this court to make any observation at this stage, and it is up to the petitioner to consider the same. What happened, my lord? My lord, the petitioner, my lord, approached, my lord, before the division bench, my lord. My lord, then division bench, my lord, passed the order that starts from, my lord, page 100 and operative part 105, para 8, my lord. Having heard the landed counsel appearing the applicants, and after going through the materials available on records, we are of the view that it is the order, it is reiterated, my lord. Passed on so and so, and orders dated 25/1/2021, passed in IA.
Yes.
The landed single judge has kept the open the appellants to challenge the validity of the assessment order and notice of the demand issued the independence of the petitions, or after the disposal of the petition, no further order is required to be passed in this appeals, and the same are dismissed. So, my lord, in fact, my lord, the petitioner left with no other option but to approach, my lord, the forum again, my lord.
Yes.
So, my lord, this is the, my lord, by way of this, my lord, the petition has been filed. So, my lord, our prayer is that notice be issued, my lord. Let them say, my lord, whether the, my lord, now, my lord, although said that nothing survives, my lord.
You were agreed by the assessment, by the demand notice.
Assessment order and demand notice, my lord. Assessment order.
When was it made?
2020, my lord.
Now, what has happened to the demand?
Otherwise, it's appealable, my lord. Statutory appeal can be. They could not have. And one more thing, my lord. In 2014, when they approached the honorable court, this assessment was already under challenge in the writ petition. Whether they can reiterate it now, before this honorable court, they can prefer an appeal. Honorable court has given the liberty approach the appropriate forum, but not before this honorable court reiterating the same play when the writ petition has been.
Mr. Gogoi, there will be a catch.
Lordship.
The earlier assessment, earlier impugned action was under 74 of the VAT.
Yes.
Which has been repealed.
No, those cases.
Then now it has come under the GST.
No,
Now
VAT, my lord, whatever is pending is there, my lord.
Oh, by the saving
yes,
clause.
it will
By
go.
the saving clause. Okay, okay.
It can be, my lord,
You're correct.
completed.
Okay.
After 17, whatever is done, it is under GST. July or August 17.
That proceeding has not come to an end.
That, of course, my lord, I will have to seek the instruction.
No, obviously, because he would not have come to
Yes,
the
yes.
courts.
Yes.
Why don't you participate? You have already participated. Let the proceeding come to a conclusion. You have the right to appeal.
My lord, in fact, my lord.
Because all your previous endeavors to approach this court in a writ petition, then then the IA, then the writ appeal has not fructified in anything beneficial to you.
My lord, in fact, my lord, may
You
I sub-
you exhaust the remedies under the statute.
my
Come-
lord, understood, my lord, may I sub- my lord? Under the statute, my lord, the remedy is not available for the two reasons, my lord. Number one, my lord, because when the search or seizure was made, my lord, it was illegally, my lord, stated in the writ petition, my lord, by the additional commissioner also participated in that, my lord. So, my lord, because if we file revision, my
But
lord.
what about how do you overcome the submission? That was this exact subject matter in the previous first writ petition, which has been disposed of. Now, can you again raise that issue?
My lord, we can, why you can issue, my lord?
Unless there is a subsequent cause of action, or a new cause of action, maybe that was the starting, but we have not proceeded anything.
My lord,
The same cause of action which you are now trying to espouse.
My lord, may I submit, my lord? May I submit, my lord? Your lordship has rightly put positive question, my lord. My lord, may I reply to it, my lord? In fact, my lord, when my lord, but illegal search and seizure, my lord, violating the provision, so my lord, because I am need not bother your lordship, my lord, is a Buja Dambuja, Wildfool, where the my lord, the provision of law is violated because without protective law.
No, we are not on the availability of alternate. We are not on Whirlpool. We can understand that Whirlpool has given certain restriction, but that is not a complete embargo or a blanket. That in all cases we said we should say no in appropriate case. But there is another aspect here. The say subject matter was taken up for consideration in an earlier writ petition which has been disposed of.
But my lord, lordship observed then, my lord, that
you can appropriate in the appropriate forum. Does it mean that you can come again to the writ court? And that observation of the single judge has been upheld by the division bench. We are bound by it.
My lord, may I submit, my lord?
This is not a fresh cause of action.
My lord, quite true, my lord. My lord, one of Landless single judge said observed.
I think you'll have a difficulty, Dr. Tul.
My lord, may I submit? My lordship will kindly or my lord, let them file affidavit, my lord.
No. Affidavit, why should they file? We are not even convinced to issue notice in this.
My lord, may I submit?
There are
We have also written to my lord. What happened, my lord? Thereafter also, my lord, I am coming to that, my lord.
No.
We have written to them, my lord.
Dr. Todi, we are not on the merits of the case. You may have a very good case on merits. We are only on the procedure to be adopted.
Procedure, my lord,
Procedure, whether a writ court have another proceeding on the same cause of action which has attained finality by a DV judgment.
My lord, where will go, my lord? We have not.
You file an appeal, let the proceedings be over.
But appeal, my lord,
These
does not lie.
proceedings were not interfered with by the court.
My appeal does not lie, my lord.
No, this proceeding was not interfered by this court. Can we again a single judge take up the issue?
My lord, what happened? What happened?
Your endeavor to challenge the IA order has is gone against you.
My lord, what happened, my lord? What happened, my lord? What happened in this case? My lord, when Landless single judge, my lord, at the relevant point of time, 2019, my lord, stated that, my lord, neither, my lord, said that so correctness of the judgment, my lord, order was not search or seizure, not looked into.
It is on this issue which we are trying to extract something from you. What is the doctrine of constructive res judicata? Where will the Dragonro case go? Dragonro Jadon, what was the case?
My lord, in fact, my lord, then my respect.
Dragonro.
Respectfully, my lord, I will submit, my lord.
Dragonro Jadon versus what bank? Central Bank of India.
My lord, then my lord, respectfully, I will submit one respect matter. My lord, but what happened, my lord?
Will not be maintained.
But if the matter would be decided, or my lord, what happened? What happened, my lord?
Matter of constructive res judicata.
My lord, res judicata, my lord, is judicata, my lord, then I can be remedialist, number one. My lord, when I file appeal, when writ appeal, my lord, writ appeal, then my lord, lordship also observe the same thing. That you
we are bound by it.
But this is the approved form. Approved form is my High Court is approved form.
Appropriate forum you had approached, it was dismissed. Writ appellate court has affirmed.
No, not dismissed. Not dismissed, my lord. That is the case. My lord,
we have read this.
Yes, my lord. Let me.
You will see page 90.
My lord, if my lord dismiss, if it dismiss, my lord, then my lord, yes, I am wrong, my lord. Because it will not, because I cannot reiterate it again. Reiterate it again. It was not dismissed. My lord, let me read, my lord. What?
I have read page 92. No observation.
No, in fact,
Para 9, my lord.
Later on,
reopen it again, my lord.
No, my lord. Lordship, may kindly, my lord, come to the, my lord, please come to the, my lord, IA page 97, that was second one, that page 98. But we have not gone to the correctness of the impugned search and seizure. That means no observation, neither allowed nor dismissed.
If any cause of action still survives, the petitioner will be at liberty to approach the appropriate forum.
But neither, my lord, neither court allowed, no dismissed. But that's why, my lord, we filed writ appeal. But when, my lord, in fact, my lord, if the matter would have been, my lord, may I say, my lord, may I submit? Lordship will kindly give me, my lord, 2 minutes time.
Yes, yes.
But if, my lord, the case would have been dismissed by the landed single judge, and my lord, the appeal also dismissed, got dismissed, then, my lord, we have remedialess, we have nothing to accept Supreme Court, nothing is survives. Here is the case, landed single judge, my lord, neither allowed nor dismissed because it would have been necessary, right, my lord. Then what happened? That was made, that was corrected even, again, it used specific words. In IA, we have said that we have not looked into correctness of the order, such and seizure. That left open, nothing. And only, my lord, when nothing left, was decided, it was decided, neither this or that way, nor in their favor, not in our favor. Now, my lord, meaning thereby, the case remains open, issue remains open. If the issue remains open, my lord, then we have the right to edited the issue. Now, edited issue in the appropriate forum. Appropriate forum is the High Court, my lord, because the earlier also the same issue, High Court is the appropriate forum because the departmental head, they were also involved in the issue. So, my lord, as far as statutory provision, under 226 only it was the remedy. If, my lord, the High Court would be decided against us, or then, my lord, nothing survives, or in favor, nothing survives. Lordship may kindly see, here, my lord, in IA, it was said that we have not looked into correctness. This court affidavit filed by the not going to correctness of the order. Here, my lord, Lordship will kindly see, it's an earlier also. If the melody issue is there.
Now, what we want to know the status of the case. See, while reading the observations of this court in paragraph 9, this court just in the preceding paragraph 8 has said that you have taken into recourse the VAT Act of 2003 to conduct search, but at the same time, you are also required to follow the procedures under 47 and 100 of the CRPC. But what is the objective behind making the observation at paragraph 9? Since the search and seizure is of the year 2014, this court is of the view that it may not be necessary to make further observations. May not be. Why? Because in the meantime, 5 years have passed.
Yes. Now,
so we want to know if from 2014 in 2025, what is the status?
Yes. Regarding
Mr. Dr. Teddy may be right in contending that the court has said that we are not entering into the matter because sufficient time has elapsed. And at this time, it may not be necessary for the court to make any observation. Now, you place before us, we'll have this on when? After a week?
Yes, sir.
You place before us the status. What has happened? Where have you stated the present? Where have you stated the present status of the case? Which paragraph? What has happened now? Presently. From 14, 11 years have passed.
My lord, that, my lord, objection, my lord.
Okay, we'll have this on Tuesday next or Wednesday next. You have a week's time. Okay. Heard Dr. Todi, BP Todi, learned senior counsel for the petitioner, as well as B. Gogoi, learned standing counsel finance within bracket taxation. Taxation?
Yes,
Department.
taxation.
The case in hand has a checkered history which relates back to a writ petition filed in the year 2014, which had culminated in an order dated 5/11/2019, full stop. This court in the said order had observed that since sufficient time had elapsed, there may not be a requirement for adjudication and if any cause of action survived, the petitioner would be at liberty to approach the appropriate forum. Full stop. It also transpires that subsequently an IA was filed, which was disposed of on 25/1/2021, followed by an order dated 22/2025 passed by the Honorable Division Bench in WA 4 of 2022. Para? In view of the aforesaid background, Sri Gogoi, the Learned Standing Council, is directed to obtain instructions on the status of the proceeding. Full stop. List this case on 13th of August. Full stop. To facilitate Sri Gogoi, the Learned Standing Council, to obtain the instructions, let a copy of the writ petition along with the enclosures be served upon him during the course of the day.
Only my lord, what happened, my lord, in the only word, my lord, but that might have created problem, my lord, but otherwise it is in our favor, judgment.
Let us see.
Much of it.
Judgment is not in your favor.
But nothing serves, what happened, my lord, ought to have, my lord,
The cause of action has not been touched. If you say it is in your favor, that means there is a judgment.
What to have, my lord,
There is no such observation, either in your favor, it is not in your
Yes,
favor.
madam.
They may constitute to be in their favor,
But
which
they are,
we may also accept.
they are constituting
But it cannot be.
interest of the
If
world.
the judgment is in your favor, you should not have come to the court again.
So they are taking the advantage, my lord, so not set aside, that is
Okay,
the
okay,
only
next-
what is, anyway, my lord.
Next.
Much okay.
Next date we'll see.
Much okay.
Yes, Mr. Dhar, you are the standing counsel.
I am not the standing counsel, although I am looking after the cases of
Okay.
Sri
Can you, we can
Wednesday,
request you to have the instruction.
Wednesday, my lord, I'll take that.
What I was praying.
We'll have it on Wednesday.
Yes.
Wednesday, okay? Wednesday.
Both can go have a site inspection in presence, whatever.
No, Wednesday we'll see. Wednesday. On our third Sri S. Bonik, Learned Counsel for the petitioner. First of Sri A. Dhar, the Learned Counsel, who is present in the court, has however clarified that he is not the standing counsel of Silchar Municipal,
Sribhumi Municipal
Sribhumi Municipal Corporation
Board.
Board. You have made a corporate board, Sribhumi Municipal Board. Full stop. However, he invariably appears for the same board. Full stop. This court accordingly requests Sri Dhar to obtain instructions in this matter, which is to be listed for motion on Wednesday.
Wednesday.
Furnish him with a copy.
I have received the copy. Oblige.
What's so? Sixth. Sixth. Motion made. Yes, Madam Bhattodoba.
Right, please, is well.
Where is your senior?
He is not well.
Not required. Okay. Yes. What is it?
Lordship, in this case, the secretary and president of the committee informed the deputy commissioner that he is not authorized to file this case on their behalf now.
Sorry.
Now, what about the direction of the Supreme Court? Have you followed the direction? The deadline is 12th, I think, Madam.
Lordship.
Yes, Lordship. It is on 12th and there is an.
Whoever comes to the court, we are not too much bothered or
Look,
concerned.
That is true.
We are concerned about compliance of the direction of the Honorable Supreme Court.
Lordship. But this person is concerned, Lordship, he is not authorized to
Madam, you are not authorized.
file.
Lordship, as of now, my only prayer is that there is a duty cast on the administrative machinery, Lordship.
You
by
are
the
not,
Constitution.
you are not authorized. Why should we listen to you?
I am authorized. How come I am not authorized? He has to prove that.
Yes, I prove, I have the proof, Lordship.
Okay.
Lordship.
Heard Miss A. Begum, Learned
And
Counsel.
Begum, Lordship.
And Begum, Learned Counsel for the petitioners. Also heard Sri N. Goswami, Learned State Council. Full stop. Para. Pursuant to the order dated 30/7/2025, Sri Goswami, the Learned State Council, has obtained written instructions which has been placed before this court. He has submitted that as per the instructions, the present petitioner is not authorized to file or maintain the writ petition. Para? Do the aforesaid submission would be taken into consideration, which is a relevant one, would require consideration, comma, the concern of this court is with regard to holding of a meeting on or before it 12/8/2025 as per direction of the Honorable Supreme Court. Full stop. Para? Accordingly, this court directs the state respondent to file an affidavit on the regard of authority of the petitioner. Full stop. At the same time, comma, the respondents, official respondents are directed to take all steps for holding the meeting in compliance of the order of the Honorable Supreme Court, irrespective of the fact of pendency and maintainability of the writ petition. This when? After 2 weeks.
Lordship, since Lordship has already observed that, could Lordship observe that this letter has been stayed, Lordship?
No, where are you staying? We're not saying anything. Yes.
Lordship, it is until further notice that they have said, and they would take a lot of time to file an affidavit. The order of the Supreme Court.
We said 12/8, we have already reiterated. Let us see if they do not do
This is
it.
the last date, Lordship.
If they do not do, there will be a contempt.
Lord.
Let us see. Yes, next.
Much.
2 weeks.
Lordship, could the date be fixed, Lordship, not 2 weeks?
Date, yes.
Before that, Lordship.
Before that, tell us when. Today is what, 4th?
Yes, Lordship. Maybe on 10 days.
On 11th.
Lord.
क्या बोला? Last में क्या बोला? This case on 11th.
And also, Lordship,
18
if I
lots,
could get
18 lots.
No, take instruction 11th. You have to hold the meeting. You just need to tell us.
Lordship, also, could I get a copy of the instructions? If he.
That is an internal communication. Why should we give the instruction? It's a letter written to him.
Since he is alleging that it is not maintainable, Lordship.
That is why we have asked him to file affidavit.
I'll file it.
Much obliged.
Oh, there is a direction. Yes, there is a direction to file affidavit one. Last may clear. Though the affidavit may be filed within a period of 2 weeks, comma, taking into consideration the date fixed by the Honorable Supreme Court, list this case on 11/8/2025, on which date the instructions, the status of the status is to be apprised by the Landless State Council. Okay. 11th we'll have the case, but your affidavit can come in 2 weeks, no problem.
25.
16 matter, anything remains?
We don't have the instruction. We have been always trying to contact the petitioners. The matter relates to the conversion of the land ownership, the housing board.
Yes, Mr. Gogoi.
Lordship,
Is there anything remaining in this writ petition 2016, 9 years?
In terms of ownership of the rental premises, Lordship, it is up to the government of Assam, Lordship. We have submitted proposal to the government of Assam. It is laying in the government table, Lordship. It is government of Assam, Lordship. Otherwise, the rent, the 500 already been executed and they have been already paying, Lordship. Nothing.
You are an
remains,
association.
Why not?
What do you want?
We want the conversion of the land. We have been staying there for the past so many years. There's
Conversion of land.
and also it's the housing board complex has been in the dilapidated state. That was our prayer.
Yes, government. Can you claim as a matter of right? You were beneficiaries of a government
Yes,
scheme.
yes.
Given certain houses, out of lakhs of people, you have been given the benefit. now you say that the ownership is also required to be given to you.
Since there was a.
Now rent only 500 lordship. Yes.
I know you are a privileged class. People are homeless.
Yes.
Now you want the ownership also. Under what basis? What is your right?
It's an old matter, but if sometime I may get in.
No, we are closing this. Heard 3M Smith, learned counsel for the petitioners. You are still in occupation.
We don't have the instruction, it has been.
There have been many dismantling of houses.
Still they are in occupation, lordship. We are trying to contact them in the previous old matter.
Okay.
Registration certificate is also up, valid up to 2017.
Of the registry, no, thereafter, I think,
Nothing.
M. Smith Learned Counsel for the petitioners also heard 3 and thus Learned State Councils
Respondent number 1.
as well as with T.R. Gogoi,
Respondent 2 and 3
standing counsel for the Assam State Housing Board.
lords.
Full stop, para. The writ petition is pending since the year 2016. Until now, no affidavit has been filed. Para.
Lordship, we have filed the affidavit in 2019, 29th of May, lordship.
You filed?
Lordship. Earlier, my submission was wrong, because of earlier, I am not in there, lordship. It was filed on 29th of May, 29th of May 2019, lordship.
I don't think so. We don't file affidavit. We don't file any affidavit. There is no affidavit.
Lords.
Well, do you have a copy?
Lords.
Yes. Have you been served with a copy?
No, but we have possible.
It might be,
Let it be on, let them file them, we will.
it might be on the record.
Don't do this. No affidavit. As regards the issue of exchange of pleadings, Sri Gogoi has submitted that the brief which he is holding contains copy of an affidavit filed in May 2019, which however is not with the court records. Para, be that as it may, comma, as per the facts projected, comma, the petitioner number 1 is a society consisting of members who were allotted houses under the slum clearance scheme in the Kharguli Hills, Guwahati, by the Assam State Housing Board. Full stop. They said allotment was done about 3 decades back and there was no maintenance. Full stop. The petitioners had accordingly approached the authorities for granting ownership of the premises, including the land, which was, however, not acted upon. Para. This court, wide order dated 5/2/2016, had issued notice Full stop. It however appears that when the matter was listed thereafter on 12/4/19 and 11/1/2021, there were no representations on behalf of the petitioners. Full stop. Tara, M. Smith, the learned counsel for the petitioners, who is present today, has submitted that there is no instructions from the clients. Full stop. This court has also noticed that on the previous occasion, that is i.e. on 28/4/2025, a similar submission was made. Para? Though the petitioners have claimed, have prayed for a direction to the authorities to consider grant of ownership, no legal right in support of such claim has been able to be demonstrated. Full stop. Granting of ownership of the land is ultimately the prerogative of the government, which is to be done by following the due process of law. Para? In view of the above, this court is of the opinion that since the claim has not been able to be related to any enforceable legal right, no relief as such can be granted. Full stop. It is, however, left open for the government to consider the prayer of the petitioners, if so made, which, however, is to be done strictly in accordance with law. The petition stands disclosed.
My lord, in the year 2007, 93 persons filed a writ petition who are landless people, praying that some land should be allotted to them for residential purpose. And the Honorable High Court passed order that Lordship may kindly see page 12.
Yes.
And operative portion may be seen page 25.
25.
25 bottom.
Yes.
In view of the specific amendments made by the respondent number 2 at paragraph 6 and 7 as quoted herein above, so many numbers have been given, my lord, here.
Yes, yes.
Versus number. The respondent authority is directed to examine the genuineness of the claims of the remaining 19 petitioners, that is writ petition number so-and-so, and we are 26, 46, and 62, my lord. Then page 26.
Yes.
If after verification and scrutiny by the opposite appropriate authority, the cases of the aforesaid 19 petitioners are found to be genuine, the authority shall do the needful to allot the land to the 19 petitioners as has been allotted to the other writ petitioners. The authority shall also look into the cases of the petitioners at serial number 3, 33, 34, and 56 and do the needful. The whole exercise is to be completed within a period of 6 months. Now, my lord, after passing this order, government has allotted certain plots of land to certain persons. But with the 3, here is the 3 persons, they have not been yet allotted. So we have filed a representation, kindly see page 27. This is a representation annexing the order of the Honorable High Court.
Yes.
But this representation is under consideration of the government, but no order, effective order is passed. Nor they have filed affidavit till today. So my prayer is this, my lord, let the government consider my representation in terms of the Honorable High Court's order.
But now representation filed in the year 2017.
That is true, my lord. But they have done anything.
New land policy has been come.
No, we have no objection on the basis of new policy because we are landless people. So, if necessity,
you file new application. If you file, that will be considered.
Bosundhara lordship, they can apply.
Land of Bosundhara. If you apply, it will be
If it is a
considered.
landless person, the
Yes.
Bhopal will consider. Lordship.
Third,
may be.
Sri M.U. Mahmud Learned Counsel for the petitioners. Also heard Sri J. Hendik Learned State Counsel, as well as Ms. J. Hadarika Learned Standing Counsel, Revenue Department. Para, please have your seat. Considering the facts and circumstances and also the fact that this writ petition is pending since the year 2017, the same is taken up for disposal at the admission stage, full stop. As per the facts projected, initially, WPC 2142 of 2007 was filed by 93 numbers of petitioners, including the present, including the present 3 numbers of petitioners, with a prayer for allotment of land. Full stop. In the said proceeding, a stand was taken by the authorities that 19 numbers of petitioners, including the present petitioners, did not have possession or dwelling houses in the Sarkari Dag number 1 of Dhanbandha VGR. Full stop. Accordingly, the said writ petition was disposed of while an order dated 16/7/2009 directing the respondents to examine the genuineness of the claims of the petitioners. Full stop. The petitioners accordingly had filed representations for such allotment which has not been acted upon. Full stop. The Sri Mahmud, the Learned Counsel for the petitioners, has submitted that land has been allotted to similarly situated persons and the petitioners have been left out. On the other hand, both Sri Hendik and Ms. Hazarika, the Learned Counsel for the respondents, have submitted that the cause of action itself has been rendered otious by introduction of the new land policy. They have also emphasized on the Vasundhara scheme under which a landless person can apply for allotment of land. In view of the aforesaid development and change of scenario, this court is of the opinion that no effective relief can be granted to the petitioners in the present petition. Full stop. The petition is accordingly closed. Full stop. The petitioners are, however, given liberty to apply under the existing land policy, including the Vasundhara scheme, for allotment of land, and if that is done, the same be considered by the respondent authorities strictly in accordance with law.
May I say timetable, madam?
You have not even file it.
After filing a timetable.
Timetable is for classrooms, not for court.
Obliged.
Yes. 28 is.
May I please your lordship? My lord, the petitioners is not in contact with me from last many years, my lord. So time might be given to me.
After 2017?
From 2019, honestly, my year.
Then we are closing it. They are not interested.
My lord, they might have received or he may died also. I do not know anything.
So we'll record yes. We'll record your predicament, don't worry.
Yes.
I heard Sri Talukdar, Learned Counsel, I.A. Talukdar, Learned Counsel for the petition, also heard Sri J. Henrik, Learned State Counsel.
No, my lord, I am appearing on behalf of respondent number 4.
Who is for?
My lord, that electrical inspector.
A State Counsel. State Counsel for the respondent number 4. APDCL, anybody? APDCL, who is there? Mr. KP Pathak?
Pathak.
Is he there in the court? Any APDCL member, standing counsel is there? APDCL. No, we will record the name. We are going to close this. Whom have you seen in the court? KP Pathak, is he around or anyone?
I got the name of D. Gogoi, Dixit Gogoi.
D. Gogoi is there?
3 weeks time may be given.
We are not even giving 3 minutes time.
Yes.
Are you sure Gogoi is there in the court? He may be in Dhemaji, then it will be difficulty.
Let me confirm that I have just hurriedly seen him, my lord.
Seen him hurriedly.
Hey, my lord, keep on moving, my lord. Not, I will find it done.
Okay. Also, I had D. Gogoi, as well as D. Gogoi, learned Standing Council APDCL, para. The claim in this petition was with regard to a compensation of rupees 25 lakhs for the death of the son of the petitioner with the allegation of electrocution. Full stop. It is alleged in the petition that the deceased was about 10 years and a student of class 4 when he had met with the accident of electrocution by connecting with an electric pole. Full stop. It is the petitioner has alleged negligence. Full stop. Para. Sri Talukdar, the Learned Council, has, however, fairly disclosed that the client is not in touch with him for a long period of time. Para. We have also both Sri Gogoi, the Learned Standing Council, and Sri Handik, the Learned State Council, has however submitted that compensation for electrocution is under a particular scheme where an amount is specified. Full stop. Para. R.R. Gogoi, D. Gogoi, R.R. Gogoi. R.R. Gogoi. Instead of D. D will be replaced by R.R.
R. Bora.
R. Bora, sorry, R. Bora. R. Bora.
28.
What is your report, Mr. Handik? Handik?
Lordships, I don't have. As of now, the inquiry report is not there.
Since the Learned Council is not equipped with the instructions, this court is of the opinion that the writ petition be closed with a direction that if any claim is pending, the same be considered in accordance with the existing scheme.
Right.
Full stop. Existing scheme for grant of compensation. Item 30. P.N. Goswami, I Kolita. Mr. Bora. Where is he gone? I think Bora is with P.N. Goswami.
Lordship, I'm appearing on behalf of CBI Retainer Council. She is on legs in another court.
Who is the council?
CBI.
Mr. Bora, I think you're my chamber matter. Your chamber matter, I think. Next, item 30. You're connected with Mr. Goswami, P.N. Goswami.
No, I'm only in APDC panel, Lordship.
Okay. Where is I Kolita? Where is R.R. Gogoi? Who is your senior, madam?
MS M. Kumari.
For the CBI?
Yes, Your Lordship.
When did the petition was appeared to?
Lordship, when the pass over this matter, I will inform you.
Just a minute. I think there is no existing cause of action. The petitioner was directed to appear before the CBI at Kolkata.
Sure.
And the lockdown was there at that time. So this petition was moved. Now thereafter matters have, and the situation has changed.
Probably he had also appeared.
If they have appeared, nothing, it
Remains.
Lordship, will seek instructions from CVA.
Your lordship may kindly fix it at 2.
I will have it at 2 o'clock.
Yes.
Okay.
Okay.
I'll inform.
If they have appeared,
Yes,
there's nothing to be
remains. Yes, yes. Obliged, lordship.
to continue with this petition. We can close it. Yes, next.
My please, lordship. If I am paying exorbitant for the day only.
Last two times you have not appeared and you don't have instructions. What is there?
My lord, today also, my lord, I tried to contact my lord. Even my lord, my friend Deepak also can take instruction whether
No, we're closing it. We'll give some observation. Yes, somebody had died due to some. What was the reason of the death? Elephant. Wild elephant. Attack by wild elephant. Forest department. Anyone from forest department? Botakur or whoever. After a while,
my lord,
we'll close this. We'll make
My
some
lord,
observation
after-
that if you are entitled, it will be considered.
my lord. I am.
You'll be around, Mr. Kondokar, after some time, maybe at 2 o'clock.
May I please?
Yes.
The lordship had taken up this matter at 2 also.
Why?
I mean, when Mr. P.S. Deka, he is on legs. So, BFPC.
He will appear, okay.
Obliged.
What is the subject matter? No idea. Okay.
Yeah, it is
Okay, at 2
a
o'clock.
non-payment of it.
Let the petitioner was dispossessed from our land, my lord, by the respondent number 6 and the police authorities. Now the GMC and police, they have filed their reply. The private respondent is to file a reply, my lord. What is his?
Who is appearing? Mr. Midhi, you are appearing. Private respondent.
May I please, your lordship, I am appearing for respondent number 6, the private respondent.
Filed.
Lordship, I humbly pray for some time to file my reply.
22 matter. When did you appear? When did you appear?
In 22 itself, lordship.
Then you take 3 years to file an affidavit in opposition.
Lordship, we are waiting for the reply of the state authorities, lordship. Now we will file a reply, lordship. Lordship, apparently, lordship, the dispute is between the petitioner and the respondent authorities, lordship.
What is your cause of action, Mr. Das?
Cause of action, it was a plot of land, my lord. There was a high court order, my lord, that he was running some cattle, cows, my lord, cow shed. Now there is a complaint from the authorities. So without show cause, my lord, they went to demolish.
Which place?
Adgaon, my lord. The Honorable High Court, my lord.
And Mr. Medhi, you are how are you connected?
Lordship, I
He
was
is
the
in
owner of
possession
the
of that
property,
land,
lordship.
You are the owner of the plot of land. You don't have any problem with him.
Lordship, I have to seek instruction, lordship. At this moment, lordship, it will be difficult for me to. By way of an affidavit, lordship, I will bring on records.
Okay, 2 weeks. But you file it 22
I
matter.
will file my reply, lordship.
While affidavits have been, while pleadings have been exchanged between the petitioner and the official respondents, comma, the affidavit is yet to be filed by the respondent number 6. Full stop. PP Medhi, learned counsel for the respondent number 8.
6.
6. Prays for some time to file the affidavit para, considering that the writ petition is of the year 2022. 2 weeks' time is granted as a final opportunity.
I'm obliged.
I'm obliged, lordship.
May it please your lordship.
Yes.
Lordship, in this case, I'm appearing for SBI Life, your lordship.
Yes.
In the last occasion, your lordship was directed to bring instruction as to why the insurance proposal was rejected by the insurance company. I have already communicated with the officials, your lordship. I need some more time, your lordship.
Okay.
On next Friday, your lordship can take them.
But you said that the amount was refunded, so there
Amount
was
was
no
refunded.
privity of contract,
No,
there was no concluded contract. That was
Yes.
your submission.
But your lordship wants
Okay.
to know the.
No, we not just want to know, yes. Hertzfree R. Fukan, learned counsel for the petitioner. Sahewala is there.
He was here.
He was here. Also Hertzfree A.K. Sahewala, learned counsel for the respondent bank. As well as Sri H. Buragohai, learned counsel for the respondent number 4 insurance company. Para? On the prayer of Sri Buragohai, the learned counsel for the respondent number 4, matter is adjourned by 2 weeks.
1 week.
2 weeks to enable him to obtain instructions with regard to the reason for non-acceptance of the proposal for insurance of the deceased.
Complaint.
Item 26.
Yes, Mr. Chaudhary?
But otherwise, the matter was fixed on the last date for examination of the citation which was submitted by us. Can it be a 2, my lord? May I please have?
Mr. Nayak? I think last occasion he was there.
He was there, my lord.
You had cited Pankaj Mohan.
Yes, my lord.
And what about the aspect of challenging the division bench? He said the matter was pending consideration before DB.
This, my lord, I have not been able to obtain the information. 36. As of now, my lord, this has not been. As of now, this is in force, my lord. That is all.
Okay.
Maybe taken as
at 2 o'clock. Okay, at 2 o'clock we'll take up other matters.
May I please, my lord?
Yes.
My lord, instructions have been received by Mr. B. Gugoi, my lord. He's on legs in court number 1, my lord.
Motion matter.
Regarding the so called whether they would like to withdraw.
Yes,
Can we have it tomorrow?
My lord.
Tomorrow?
My lord.
Okay.
My lord.
On a request made on behalf of Sri B. Gogoi, Learned Standing Council, Finance Taxation Department, list again tomorrow.
Can you day after tomorrow, man? Day after tomorrow.
Tomorrow, there is a problem or what?
Is some difficulties.
Day after tomorrow, this court will rise early.
No, tomorrow, man.
Motion will do.
Yes,
No
ma'am.
problem.
Tomorrow,
We'll rise around 12 o'clock. Whenever you say.
Tomorrow, let's day after tomorrow, man.
Day after tomorrow.
Deeply obliged, man.
I'm sorry, my lord, was on legs. My lord, lordship would like pedos of similar.
Is there anything? Now,
Nothing but my lord's order can.
this was only for the purpose of COVID. Now that the situation.
Sir, he has appeared, given his statement, but my lord,
The grievance was only with regard to that protection.
yes, my lord. I have this order will also cover, my lord. Has been given liberty.
Anyone for the CBI? CBI, there's who appears? Somebody had taken time on behalf of Madam Kumari, M. Kumari, I think.
CBI now this madam is there.
Will record her.
Yes, that's paragraph 9, my lord.
9.
9, paragraph 9.
We'll not have such a elaborate order. We'll make it very simple. Hard. We Gogoi, learned counsel for the petitioner also heard, what was her name? No, the lady had appeared. Did we? No,
I
appeared. No, for her, somebody had appeared.
Madam Gayan was there.
Her colleague chambermaid had appeared there. Also heard.
I'll try to get the name and.
Yes, at least one name of the associate. For the CBI and Sri J. Hendik for the state respondents. Full stop. Sarah? The cause of action was a cause of action espoused in this petition filed in the year 2020 was with regard to a proceeding wherein summons were issued to the petitioner along with that of the general manager of a daily newspaper by the CBI. Full stop. The petitioner has alleged that there was a misuse of power and only with an intention to harass, such summons have been issued. Full stop. When this matter was taken up on 6/3/2020.
This is subsequent to that Jointa Bura was called earlier. This matter was moved on 14/10/2020.
No. Should check the record, Mr. Gogoi. Just don't make a submission like this. When this matter was considered on 6/3/2020, this court was apprised of the earlier case involving the general manager of the establishment. The matter was accordingly directed to be listed on 22. What is this? 22/4/2020. Full stop. However, the matter was listed on 14/10/2020 thereafter, when this court was apprised that due to the ongoing lockdown at that time connected to COVID, the petitioner could not appear on the date fixed, which was on 24/3/2020. Full stop. After hearing the parties, while notice was issued, the interim order passed earlier on 6/3/2020 was extended, subject to the condition that the petitioner appears before the authority on receipt of summons. Sri Gogoi, the learned counsel, has submitted that in the meantime, the petitioner has appeared before the CBI and his statement has been recorded. He has also placed before this court copy of an order dated 30/7/2024 in a writ petition instituted by the who was Jointa Burwa with the
proprietor, my lord.
He is the
Proprietor of the
by the proprietor in WPC 9282 of 2019, whereby the said writ petition along with two other writ petitions were disposed of by observing that the petitioner would be at liberty to approach the appropriate court in the circumstance the respondents take any steps which is in contravention with the existing law. Para? In view of the aforesaid development and the earlier order dated 37/2024 in similar writ petitions, the instant petition is closed by observing that instead it is closed, it is needless to observe that in case of any violation of the procedures or law by the authority in conducting the proceedings, the petitioner will have the right to approach the appropriate forum. Para? Interim order passed earlier stands vacated. The petition stands closed. Objection. প্রথম তো হেরি জবটা বড় টু হেরি 9 to 82 প্রথম সাইড বলে
CBI.
Okay, we have recorded your name. We have closed this.
Yes, I have taken the instruction. Charge sheet has been filed and another supplementary charge sheet, 4 numbers filed in Bhubaneswar. So this matter has been taken by Supreme Court's order related to Rose Valley. And
Okay, we'll Miss M. Kumari, huh? Miss
and
M. Kumari,
that notice has been issued under section 160 for the purpose of investigation.
Miss M. Kumari,
Those who are investor, their statement is
learned
so it will
counsel
be
for the CBI has
disposed of.
has submitted that in this case the investigation is over,
The
culminating.
investigation is still going on, sir. Some
And
charge
charge
sheet,
sheet, how did you file the charge sheet?
supplementary
No,
begging.
initial charge sheet without investigation of being over, how did you file?
So supplementary.
When do you file a charge sheet?
Bhubaneswar.
When did you, why do you file a charge sheet? When, at what stage? During the investigation or after completion?
No,
Only to save the time.
No, they have prayed, they have prayed in the
Madam,
charge sheet.
supplementary charge sheet is a different connotation.
173.8.
173.8 has a different connotation. It's a further investigation.
Yes.
That we understand.
That is for
But
supplementary.
can you file a charge sheet while the investigation is still going on? You
Yes.
cannot.
So
These
it
are
is
misuse,
better.
these are misuse of powers.
No,
Only
it
to
is-
overcome the statutory period.
Because this crime has been done
Okay,
all
don't-
over
don't
India.
say- don't say.
So is
It-
investigation is still going on.
In this case, the charge sheet has been filed, followed by a supplementary charge sheet.
Yes, sir.
Okay.
Yes, Lord. Sir. And
And
further investigation is still going on.
She has
There are
also
number of
informed-
FIR.
She has also informed that since the magnitude of the offense is huge, further investigation
Yes, your Lord. Sir.
under section 173 within bracket 8 of the CRPC is going on,
This is with the order of the Supreme Court, your Lord.
which is in accordance with the order of the directive of the Honorable Supreme Court. Okay, we have closed this.
Much obliged, your Lord. Sir.
Yes, next. Yes, Mr. Kondokar.
My lord, very close matter.
Okay.
If not given, after considering the, with due verification. my lord. If she is entitled, that's fine.
One district. Heard Sri M.R. Kondokar, Leonard Counsel for the petitioner. Also heard. Yes, you Google for?
My lord, I am for the state, my lord. Otherwise, the Karbi Anglong is the authority.
Forest.
No, this is not Karbi Anglong.
It's DFO.
Also
Karbi
heard, you are appear for KAC. Who appears for KAC? The J. Chutia is there.
It is still there.
Is he there in the court? Have you seen Mr. J. Chutia today in the court or any of his associates?
I saw one associate.
Name?
Name, I don't know, my lord. I'll give the name after. Ask her to appear. Yeah.
Also heard.
Some Camprai.
Yes.
Mr.
Well, S. Kemprai.
Leonard Thompson appearing for the KAC. Now, the forest. Also heard 3D Google Leonard Standing Council Forest. Finance, anyone for finance? B. Gogoi for finance department. And us for the official respondent. And Miss S. Kemprai, Standing Council KAC. The grievance of the petitioner is in connection with a claim for payment of ex gratia for loss of human life by attack of elephant. What do you say, Mr. Gogoi?
I have DC can conduct a verification with.
Kandakar de Leonard Council has submitted that there is no instructions or connection, instructions from the client since long. Footstop. Para Sri Gogoi de Leonard Standing Council has submitted that. But is a scheme
Yes, my lord. Page
available?
Page 20,
They have
ma'am.
submitted that though a scheme for such payment is available, the same has to be preceded by a factual determination by the concerned district commissioner.
Deputy commissioner will do, madam.
Concerned district commissioner.
Yes,
no?
ma'am, district commissioner.
Fourth para. In view of the above facts and circumstances, comma. If such inquiries has not been done, comma, the district commissioner, comma, Kirby Anglong may conduct an inquiry and take steps in accordance with law. The petition stands disposed of.
I am declared. DC should have a
32, what is this?
Lordship, I tender my apology for having to.
No problem. What is it?
Lordship, I have already, Lordship. What happened, Lordship? My premises was taken on rent by the respondent authority. More specifically, respondent authority number 3, Lordship, at the instruction of respondent number 2, Lordship.
Yes.
So there is an addition to that.
Yes, then what is your cause of action? Why have you approved this court? What do you want?
Lordship. So even though there is an admission, Lordship, by the respondent authority to pay the rent, Lordship, they haven't paid the rent as yet. In fact, Lordship.
Yes, you are for whom, madam?
Performer respondent number 4.
Who is for?
4 is performer respondent. Was the caretaker of my property.
Government, PWD and.
Performer respondent number 4.
No, he is by name. He is by name. Who will pay the rent? Some authority will pay the rent.
Yes.
But why have you made him by name? He's a proforma. Your claim is against whom?
No. I'm not. He is basically was a caretaker.
No. You have made the claim against whom?
DC, Deputy Commissioner.
Yes, Deputy Commissioner. Now, what is the status, Mr. Deka? Present status?
Present status is, like still unpaid.
Unpaid?
Unpaid.
Yes.
So one affidavit we already filed in 20. Affidavit has been filed.
What do you say in your affidavit?
Well, that regarding payment, my lord. Nothing has been mentioned. Lord, let me take instruction, my lord, to payment.
See, normally we would have relegated them to the civil court, but this rent matter, but it's an office of the deputy circle officer.
Circle officer, my lord, it was shifted in that 1910, Lord, 2010, Lord.
Now, are you still running your office from the same premise?
No.
They have vacated. When did they vacate?
August 2015.
15, they had vacated.
Thereafter, we had made representation. The
claim is for which years?
From 2010 to 2015.
When did you approach this court?
We approached this court on 2020.
How do you explain?
Yes, Lordship, because our representation remained.
By filing of representation, you can extend.
Lordship,
What is not permitted in a civil court? How do you get it done in a writ court?
No, Lordship, because there is an admission, Lordship, by the authority.
Admission which year? Within the period of limitation?
16.
Where is it?
Yes.
Let us see. Then you came in which year? 2020?
Yes, Lordship.
How do you overcome?
Let me satisfy your Lordship. Let me take.
Yes, Lordship.
Page?
Page 14, the type copy.
1/4.
Oh, yes. It's a type copy and page 16 is the original copy of the original.
16.
Yes. Page 14 is the type copy, the legible copy.
Yes.
Yes, Lordship. This is a communication from the respondent number 3 to respondent number 2, admitting they are in Lordship. The pendency of the non-payment of the dam, Lordship.
Yes, please read. Who is this Parikshit Narayan Dev?
Yes, he is the former respondent number 4, who was the caretaker. Because he is also the Mojadar of Beltala Mojala also. So it was the correspondence was with him, and with the consent of me, Lordship, as the owner, it was given on draft. Your Lordship will see the annexer 1 before that, page 13, Lordship.
Yes.
Yes, below Lordship. It was an assessment done by the former respondent number 5, that is a PWD building, and at below number 2.
Yes.
This is me.
This is 2014.
Yes. They had taken on rent on 2010. Thereafter, they took.
Now from 16 to 2020, what did you do?
Yes. I filed representation dated annexer 2, page 16, then annexer 3, page 17.
Now show us any law that by representation you get your extension. How much is the amount?
The amount is fixed at.
Total amount, how much will it be?
It would be around, Lordship, around 25,000 to 24,600 or 644. That means around 24,644. Five years, 16 months.
Who is this?
14, around 15 lakhs around.
Who is this Neeli Agarwal?
They are strangers.
Huh?
I have nothing to do with them. In fact, in fact, Lordship, what I'm surprised, they are the custodian of the revenue record. They know by taking such plea, Lordship, because Jamamundi will definitely reflect who is the owner, and they are the custodian of all the land records. They are the revenue authority unto themselves, Lordship.
Now, how does the Mozart, what role does the Mozarter have?
I'm giving a specific statement.
You are the owner of the property.
No, I'm not the owner.
Then?
Sorry, Mozarter is not the owner of the property.
You are the owner of the
I'm the owner.
Then what role does
he's my brother-in-law and he was a caretaker. In fact, I mean, like, he has also filed affidavit and I've also filed reply.
What about this claim of one Neeli Agarwal?
Nothing, Lordship, because I am not privy to any such proceeding, Lordship. They in fact said that these are the petitions they have referred to. And in fact, after those petitions representation, they have on 16, they have recommended for payment of the rent.
Who is
we have
for,
no nexus. We do not
who is
know.
for respondent number 4? Who is appearing? You are for 4. What do you say? Where is your reply, Mr. Deka, to the affidavit of the government?
Yes, Lordship. That is Lordship. It starts from page 31, Lordship. And relevant portion, page 33, Lordship. Starting from para 8. May I read, Lordship? That the answering deponent denies the statement made in paragraph 7 of the affidavit in opposition under reply, and the answering deponent writ petitioner, while reasserting her claim as made in the writ petition, denies any third persons having any right, title whatsoever in the subject property, including persons named by respondent number 2 in his affidavit in opposition. In fact, respondent number 2 and 3 being the competent authority have within their knowledge who is the right title holder in respect of landed property during the period they had taken on land for the purpose of
In
running.
paragraph 9, what have you stated? You have also been vague. You have not denied.
Which one?
Paragraph 10.
Paragraph 9.
Yes, may I read?
Yes, reply to paragraph 8.
Yes. Yes. That answering the opponent while reiterating her claim made in the writ petition as regards the statement made in paragraph 8 of the affidavit in opposition under reply denies due to any initial claim of Srimati Nili Agarwal, because they said initial claim, they could not pay because of initial claim. What they are silent. What happened subsequently?
No, what happened subsequently? Are you aware?
No, I'm not.
Then why haven't you stated that these are all nothing, not related at all?
This is initial claim of Nili Agarwal with support of Assam, and subsequent claim by one Vijay Borua on the said land. No action could be taken.
Who
I
are
have
these
denied.
persons, Mr. Who are these persons?
Lordship.
Who are these persons, Nili Agarwal and some?
My lord, nearly our in our affidavit, my lord, there are paragraph 7, lordship.
See, there may be an aspect of laches here, but
Lordship.
taking a holistic
My lord,
view.
that nearly one of the who my lord claimed the my lord that property. Lordship.
But what is your stand? Is the petitioner entitled to this amount?
My lord, in our affidavit, paragraph 10, we have stated there is the civil dispute. My lord, say they have to go to solicitor. Now, paragraph 10, the last paragraph we have.
A money claim in a writ petition we could have entertained if there were materials to come to a conclusion that there is not disputed.
Yes.
Now, if they are disputing,
Lordship,
how do you go about it?
Lordship,
You may have a good case, but
make me humbly submit, Lordship. What happened, Lordship? Now, since there is an admission of due on their part, now they have made.
Which admission? They are denying. Where is
No,
the admission?
admission of non-payment of dues. That is all. That is there. I've
Where?
annexed in my yes. In my writ petition, Lordship.
Which paragraph? In your writ petition, it cannot be. It can be in their affidavit, some admission.
Yes. In their affidavit also, they have
Where?
admitted.
Where?
Yes. Let me- The Lordship. Page 15, Lord. Okay, 25, Lordship.
25.
In fact, they have reiterated.
No, we in the affidavit.
Yes, affidavit.
No, this
Annex-
is a document.
Annex to, they have.
Where is the affidavit? Tell us, show us the pleadings that they have admitted.
Okay, okay. Paragraph 4, Lordship.
Paragraph 4.
Yes, page 20.
20.
Mary.
Yes, please.
That with regards to statement made in paragraph 4 of the petition, I say that as per office record in file number so and so, maintained in land records branch of DC office, letter number so and so, dated 29/1/2010, was issued by the then deputy commissioner, allowing to see the new rented premises owned by so and so. Thereafter, Lordship.
Yes.
Para 6, Lordship. One is regarding taking on rent and regarding the amount.
This
With
is
regards to
this is
statement,
owned by Parikshit Narayan Dev.
they have stated there. They have stated.
We will go by the averments. They say that it is property is owned by Parikshit Narayan Dev.
No, in my affidavit, in the affidavit filed by the Parikshit Narayan Dev, he has stated clearly. He is the caretaker. It is a mistake on their part.
Ultimately, it will be a disputed questions of fact.
I have no dispute with respondent.
They are raising the dispute. Your dispute is not with respondent number 4. Your dispute is against the official respondent.
I'm telling, submitting also. In my affidavit, in
Yes.
reply also.
Now, where is the admission that this amount is
That with regards to, I'm reading paragraph number 6,
please read.
page number 20.
Yes.
With regards to statement made in paragraph 7, 8, and 9 of the petition, I said that the letter dated 10/3/2014 issued by CE the assessed the rent at 24,644. That is in respect of property.
Yes.
Next paragraph. That with regards to statement made in paragraph 10 and 11 of the petition, I say that soon after occupation of the new premises by the cycle officer, this school, Srimati Nili Agarwal, wife of so and so, claim ownership. Next year. 11%.
Claimed ownership of the land housing the building rented by the CEO. Who is this Nili Agarwal?
That is the year. They have taken on rent. They are newly assessed. They know.
Where is this petition? Get the records. If we find that there is involvement of a third party, then they will not intervene. Do you have this?
Let the record be called for them. What they have disposed of, how they have disposed of. They have not, we did not receive any notice whatsoever as regards claim of any strangers.
Even then, my lord, that there is no,
Hmm?
no, that the petitioner did not annex any documents regarding the rent. There is an agreement between the parties.
No.
They have to one of place. Whether, my lord, it is done by the petitioner or by the, my lord, that private, my lord, that private respondent.
No rent agreement.
Nothing has been annexed in the lead petition.
Annexer 1 was, that will reflect. The petition. That published page 12. Yes. Which was
There is no agreement. Is there any agreement?
no, basically, since it's authority, it has to be, that has to be assessed by the competent authority. That is the proper respondent number 5. We followed the as per their advice, and that has also been admitted. They have annexed with their affidavit lordship. That is the same document at page 24.
Without an agreement you give for rent, what is this? Okay, we may not be very strict on this part. This document is there.
Okay.
But this and this is of which year?
14.
14, you read 2004.
They have taken on grant 2010 after so much of persuasion. They had assessed this on 2014. By the time the rent was already pending.
This will require factual determination. If it is not admitted, it will be difficult. You get the records and try to hold of this, get hold of this document where this involvement of another party is there. There is one Nili Agarwal, one All Assam Tribal Hongha, one Vijay
So many
Borua.
parties, Lord. So many parties.
I was never ever taken on board.
That's why, my lord, that
So
in our affidavit, my lord, we have stated, my lord, this is the civil dispute.
Let your lordship consider all the documents. Lordship.
And come to paragraph 10 at page 21.
Paragraph 21.
I say that based on representation filed by the petitioner, representation dated by Nili Agarwal, All Assam Tribal Hongha, Vijay Borua, various hearings have been conducted. None of the parties have got their entitlement adjudicated by a competent civil court.
Exactly. Am I a party to such purported proceedings? No.
Which proceedings?
I was not
Somebody
given
has to ascertain an ownership. That is the stand.
No, Lordship,
You're not supposed to be a
they are the
party.
custodian, they are the custodian of the revenue record. They know everything, Lordship. They have admitted me as the owner in their own document. Let all these proceedings, case records be brought before your Lordship.
You get hold of the records. Your approach to the court after at least from 2014, 2020. Pleadings have been exchanged. Full stop. In the affidavit in opposition filed by the respondent number 2, there is a reference to certain applications of other parties seeking, claiming ownership of the premises in question. Full stop. 3, handing the London State Council is directed to obtain the connected records to support the aforesaid averments. Full stop. Yes. List after 2 weeks.
Obliged, Lordship.
Wait, please, yes, your Lord. My Lord,
Yes, Mr. Nayak. Have you checked in the division bench?
we checked, my Lord, we could not find any. No, no, we could not find any appeal by that name, my Lord.
No, not by the name, the subject matter, he says.
No, subject matter otherwise is.
He says that Pankaj Mohan is distinguishable on facts and the principle and the, oh yes, that was the submission, I think, that it was.
I would submit, my Lord, regardless of Pankaj Mohan, my Lord. Here what has happened, my Lord, 6 gardens, my Lord, land was acquired under a scheme which is known as the land acquisition through direct purchase through negotiated.
Yes.
Now, prices were agreed upon, direct purchase price was fixed, my Lord. Partial payments were also made. And then thereafter, my Lord, they said that the zonal valuation of tea land has gone down. So therefore, he'll call for a revision.
He'll call for a
revision. So that is the grievance. Once having agreed to a direct purchase price, now they want to rely on the new valuation and say, and in the meantime, they've taken over the land also.
Where is Mr. Nayak? Wait for a while. $38. Arbora. Yes, madam, what is this?
Lordship, may kindly pass over the matter for time being.
And being affidavit filed.
My lord, I'm seeking
Why,
more time. My lord, some instructions have been received from.
What is the matter, Mr. Bhattacharya?
My lord, it is a case of acquisition of land under Zamindari Act. They are banking on a notification of 1967. We have received some information from DC South Salmara. It says that acquisition was done in 1958. But
This
since
is of the Markachar district. Markachar South Salmar district.
But but erstwhile Dhubri district. So the record.
Zamindari Act.
Yes, record has to come from Dhubri. So we have written letters.
This is the fourth occasion, Lordship. The notice was issued on 24/1.
24/24.
24/1/2025.
25.
Yes. Then the mirror was fixed on 24/3, then 22/5, and then 23/6. Repeatedly, Lordship, the adjournment has been sought to file affidavit also.
There is an improvement. Notice was issued not in 25. Notice was issued in December 24.
Yes.
It's better for you. 2nd of December 2024, notice was issued.
Yes.
Yes, 8 months. Isn't it enough to get instructions?
The records will have to come here.
What records? You have not even got the instructions. A last opportunity.
Right.
Okay. Pleadings are yet to be exchanged. And Sri A. Bhattacharya, learned Standing Counsel, Revenue Department, prays for some more time. Para. Sri R. Bora, learned counsel for the petitioner, has, however, submitted that on many previous occasions, time was granted to obtain instructions. Puts the para. In the interest of justice, a final opportunity of 3 weeks is granted to enable the learned standing counsel to obtain instructions / file affidavit in opposition. List after 3 weeks.
Gotcha. All right.
39.
Okay.
Yes, maybe Lordship. This matter is relating to reclassification of the land from the commercial to agricultural.
Okay, instructions obtained.
One affidavit filed by DLR, my lord. But
We have filed.
But you will also kindly see the affidavit, my lord.
DLR affidavit.
DLR affidavit.
You have filed on 27/6.
Yes, 27/6. You will also will find paragraph 5.
Yes.
That's single normal one. Page 154.
Yes.
With regard to the statement made in paragraph 7, the opponent begs to state the reclassification suit was launched as Mission Vasundhara 3 and the application registration period is from October to so and so. The time limit for disposal of already received application is June so and so. Now regarding reopening of the service again for fresh application, Government and Revenue Register Department approval is necessary. We are not on that, my lord. Our case is, my lord, our land was initially it was agricultural land. Then we made it commercial land. Then ultimately we failed, my lord, after a few years. Then we informed them. There was an inquiry. And your lordship will find the inquiry report is page 137. 137. In the inquiry report, you find yes, right. It is now, my lord, that all they are not working as an industry and commercial. So we wanted to get it done through that from commercial to agricultural, my lord. So that process is still pending. They are not doing anything. But page 137, my lord, you will kindly have a look.
What is the process for reconversion from commercial to agriculture?
There is a well, reclassification act has been amended. Now even the commercial can be converted to agriculture.
That is what they are asking for.
Now the crux is that the DLR has already instructed the DC Sri Bhumi to look into this matter. There may be some technical problem there in the district level.
Mr. Sharma, look into this matter. If the DLR has clarified that such reclassification from commercial to agriculture is possible, you need to either say yes or you can say no, but everything has to be supported by reasons.
But they have done it okay, my lord. They said it can be done. Reports are there, my lord. Reports are there. Only because of the, my lord, land revenue. Because now they say my land is supposed by 2 bigha in a patta. Now they say you have to pay all the revenue of the whole patta, my lord. I have a land of 2 bighas land. Patta consists
Now,
of.
what is your prayer in this
Yeah,
petition?
only, my lord, from agriculture to, from commercial to agriculture is to be converted, my lord.
That is it. That is within the domain of the. That is permissible. They have not done.
Yes,
You take the
23, my lord.
Okay.
Assam
But
land.
we H.R.A. Chaudhary, Learned Senior Counsel for the petitioner, as well as we. Petitioner, full stop. Para. Pursuant to the notice issued on 4/6/2025, the DLR within bracket respond number 2, respond number 2, has filed affidavit in opposition on 27/6/2025. Sri A. Bhattacharya, Learned Standing Council Revenue, has submitted that reclassification from commercial to agriculture is permissible under the extant law, and that is to be looked into by the concerned district commissioner.
Yes, madam.
Para. Sri H. Sharma, Learned Additional Senior Government Advocate Assam, praised for some time to take instructions in this regard. Para. List on, yes, 2 weeks.
Madam, we are paying revenue, madam, they are insisting to pay revenue on commercial rate, madam. And we have already paid, madam, yes. Anyway, madam, your lordship.
List on, today's for list on, we'll have it on 26th. You get enough time, 3 weeks time. 26th.
Oh.
You have copies, extra copies?
Lordship, yes.
Yes, please get your instructions will end the matter.
Madam. Obliged to watch. No, then the.
Obliging.
Asset. 40.
For mediation of ancestral property, petitioner made an application before the circle officer at Nilambal.
Yes, notice was issued, yes, instructions.
During pendency of this application, petition, the district commissioner submitted an affidavit, my lord. In that affidavit, lordship may kindly come to the affidavit. When he has admitted that, my lord may come to page number 27.
27.
27, my lord.
Yes.
The second para, my lord. It is to be mentioned here in that the said letters, my lord, deputy commissioner submitted some letter to the director of Assam Land Survey Assam, my lord. It is to be mentioned here in that the said letter was sent to the director of Land Record and Service Assam on the basis of letter number so and so dated so and so and NC number so and so dated so and so. Received from the circle officer Nilambal Revenue Circle indirectly stated that since the revenue village has not been digitized in online Authority portal for a long time, it is not possible to meet the land record in online mode, and as a result, the revenue collection of that particular village is being seriously hampered. Further, it is also reflected that due to non-updation of land record, people of the concerned village have expressed facing difficulties in approval of bank loan and dispute. What is the difficulty here, my lord? I've been informed by the official that my application could not be processed only because the land record have not been digitized, my lord. Due to non-computerization of the record, my lord, they could not make the process, my lord. Now, my only prayer is that, my lord, so that the authorities, my lord, make the process as early as possible, my lord, so that my application can be, my lord, processed.
Yes, what do you say?
DLR, lord.
DLR.
Last now I have to say this affidavit, so I have to take
No,
instruction.
the causes which have been shown by the deputy commissioner is non-digitization of the land record, of the revenue records. Once it is digitized, then his application can be considered. Now, rejection of his application for any other purpose we can look into, but this should not be a reason. It should not be a reason for delaying the process. You take instructions, how soon can you do it?
Regarding the update,
When do we have this?
after 1 week.
We'll have this on Tuesday next. Okay? Heard Sri M.E. Islam, Learned Counsel for the petitioner, as well as Sri G.H. Sharma, Learned Additional Senior Government Advocate for the state respondents. From the affidavit in opposition filed by the respondent number 2 on 28/7/2025, it appears that the reason for not being able to process the application of the petitioner is non-digitization of the revenue records of the concerned village in the online Dharitri portal. Ms. G. Hazarika, Learned Standing Council Revenue Department, prays for a week's time to obtain specific instructions in this regard. Para. As paid for list on Tuesday next. I think 11th, 12th.
Item 41 is also on the same, my lord. Same revenue circle, same issue, my lord.
Affidavit filed.
Affidavit filed, my lord.
Same date.
Same date, my lord. Same subject matter. Here also, my lord,
On the basis of the sale deed, my lord,
Okay.
application was made for petition, but the,
Okay, we will have it on 12th.
my lord.
Next.
In item 42, my lord, here the issue is petitioner is almost a 80-year-old lady, my lord. She wanted to sell her land at the village and to ship at Bongaigaon town, my lord, to settle with her son, my lord, who is a government servant at Bongaigaon. Now, what is the problem here, my lord? She made an agreement with the, my lord, the present petitioner. The present petitioner belong to, my lord, Muslim community, my lord. The only problem is that since the petitioner is a Muslim, my lord, and the seller, my lord, she's a Hindu lady, my lord. Only, my lord, due to intercaste transfer of the land, my lord, the sale permission, even application was not accepted by the revenue officer, my lord.
May I make it short, Lordship? There are two issues involved in this case.
Yes.
Firstly, Lordship, there are applications, and secondly, because of this inter-religion, it cannot be transferred. Our contention is that, Lordship, they have to make the application under the Seva Setu. That is a portal, Lordship, under which they have to make that application by submitting certain documents which is required. That was not done by them, firstly. Secondly, Lordship, this inter-religion, there was a notification whereby it was kept in abeyance for a period of 3 months. But in case of some emergency, one nodal officer was appointed because of that. So they have to make that application through that Seva Setu so that if there is any urgency, it can be taken up by that nodal officer. But they have not made that application under the Seva Setu.
Have you made it under this?
No, as per my instruction.
So for, my lord, my application form, Lordship may kindly come to page number 21, my lord. This is
Page
the
number?
application form, page number 21 of my petition, my lord.
Yes.
Page number 21 will show that this is the application, my lord, and
Yes.
this is the format of the application, my lord. And along with this application, my lord, entire document have been submitted, my lord, and the documents, those documents also, my lord, are annexed here with.
Now, have you applied in the prescribed mode? Seva Setu, the online mode?
My lord,
You advise your client if it's not
Yes,
done,
Lord,
advise.
can this matter be taken up day after tomorrow, my lord, so that
Day after tomorrow, it will be slightly difficult. We can have it on Monday.
Monday.
Day after tomorrow or Thursday we can do, but this bench may not be there. Thursday.
Third.
On the aspect as to whether an application was made online in the Seva Setu, 3MA Islam, Learned Council for the petitioners have prayed for little accommodation to obtain instructions. Para, as requested, list on Thursday next. Para Sri H. Sharma, Learned so is present.
Lordship.
Alright, my lord.
Please, sir.
Yes.
Here, the Lordship, on 24th June, our conveyance and the goods were seized by the respondent authority. On 25th June, they issue MOB 1. On very same day, MOB 2 was issued, though we have valid bill, e-way bill. Now, my lord may see.
Affidavit has been filed, Mr.
Please,
Gaurav.
Yes, my lord.
Served upon the other
Last
side.
year, yes.
Please, sorry. Page 26 may be seen, your lordship,
Of what?
of my petition, your lordship.
Yes.
This is MOV 2. Wherein description is mentioned tobacco, though it is unmanufactured tobacco. And
Yes.
what is discrepancy, your lordship? Prima facie, the document tender are found to be defective. The genuineness of good in transit, its quantity or tender document require further verification. E-way bill not tender for the good in movement. Now, e-way bill was there. I have also annexed, your lordship. Thereafter, what happened? As per the mandatory procedure SOP, they have not issued MOB 4, 6, 7. Therefore, we approached before this honorable court in vacation bench. In vacation bench, it was stated by them, there is a discrepancy in quantity.
in our bill, it is mentioned 15,000 kg. But actually it was 25,000 kg. Therefore, reply was what? Now, interestingly, your lordship, they filed reply. Now in reply, my lord, they changed their entire version. Or I straightway, my lord may see annexure F, page 75. This is MOV1, statement of the driver. Wherein next page, page 76, commodity, unmanufactured tobacco.
Yes.
Now, my lord may see page 77, MOV2. Now,
77 is MOV1.
MOV2, your lordship. Page 75 is MOV1. Page 77, annexure G, your lordship.
Yes.
Now, my lord may see
This is 1 or 2.
MOV2.
Where do you get?
My lord may see. It may be compared with page 26 with my petition. In the
What is
MOV,
the reference to tendered document mentioned in students MOV1?
no, but from front side, your lordship, the good conveyance bearing number so and so carrying manufactured tobacco. Now, my lord may see the MOV2 which was supplied to me, which is page 26, wherein it was mentioned only tobacco. Both MOV may be compared, your lordship. What they did, I'll later explain, your lordship. Wherein my lord may find the handwriting are altogether different. Page 26 and 77.
Yes.
In page 26, it was mentioned tobacco. Now, manufactured tobacco, handwriting also different. Even my lord may compare the signature of the driver. Last portion, Kailash.
Yes. Yes.
It was also different.
Yes.
Now, my lord may turn to page 78. MOV4, the report of the physical inspection.
70?
78, next page. Date of physical verification 26 June 2025. But in MOV2, it is not mentioned.
2025 is there. 25/6/2025.
Date of physical verification was carried out on next date 26. In MOV2, date is not mentioned. On what date they have issued the MOV2. Now, in tabular form, description of good as per invoice HSN code unmanufactured tobacco HSN 2401.
Yes.
In next, description of good in conveyance manufactured tobacco. They have again changed the entire version. Again, my lord may compare the signature of the driver. It prima facie, it's not the driver's signature. Thereafter, what happened? After MOV4, if there is no discrepancy, they may issue MOV5. If there is discrepancy, they may issue MOV6, the detention order. My lord may see detention order. Wherein again, prima facie, the document tender are found to be defective. And second, genuineness of the good in transit, its quantity. Now, next page, your lordship. Why the document are not page 80, your lordship?
Yes.
Improper invoice was produced where signature of the proprietor of authorized representative was missing. Now, my lord may see page 22 of my petition, wherein it was specifically mentioned it was computer generated bill. So there is no signature. No. And second, improper CN copy was produced by the in charge of the.
Yes, Mr. Borough, what do you say?
My lord, Mr. Beach order is appearing in this matter actually. He's on legs in court number 18, my lord. And our stand we have stated in affidavit, my lord.
No, he's trying to point out discrepancies in your affidavit
lord.
and mostly in the documents which have been enclosed.
That part, my lord, Mr. Beach order will submit, my lord.
Even one more important aspect here.
Oh, the standing council is not there.
Only one important aspect. How they they are trying to mislead the honorable court.
No, that is okay. I think you should make the submission in presence of the council. When is he likely to come?
After some time, my lord.
Wait for a while.
Oblige, my lord.
Let's say 31 rupees. Yes, wait for a while, please.
My please, your worship. Does we have service of respondent number 7?
335.
Respondent number 7 already completed, your worship. I have taken steps on respondent number 6, your worship. Today, your worship.
You have taken first steps
Worship.
on respondent number 6.
Today, I have already taken, your worship.
Okay. Peruse the office note dated 6/6/2025 with regard to the steps to be taken for service of notice upon the respondent number 6, para 3. Karim, you are Karim. Karim, the counsel for the petitioner has submitted that steps for service of notice upon the respondent number 6 have been taken today. What is the cause of action? 2017?
Worship.
What is the cause of action?
It will be circle officer, your worship, issued notice to.
What is this 5/6/2017? Page 60?
Worship.
You have been illegally possessing by constructing house on a plot of land, government ceiling. Section 18. Notice in another section 18. Yes. Why should there be an interim restriction on section 18 notification? Tell us. You show cause.
On this.
From 2018, you are enjoying a stay order, and today you are saying that you have taken steps.
Earlier, I was taken, your worship. This is fresh steps subsequent, your worship. And civil case also.
Mr. Das, why don't you take this matter seriously? Section 18 is under stay for the last 6 years.
Yes. Then
Is
appeal
that the
years also,
purpose?
my lord, an extra 11, page 49, my lord. Appeal, they have preferred an appeal also, my lord. Title suit is also pending.
You have a three-story RCC structure
Worship.
on government land.
Not government land, your worship, say settle, your worship. I have to take further instruction, your worship,
No, you-
regarding the.
If land is settled, you have to tell the government that it is, you cannot, apply section, regulation 18. That is not your case.
Due to the pending of civil suit. It will be civil suit to 2013.
To communication part. Both the month.
Communication one, I think.
What are written licenses?
তাতে কিবা ইনজাংশন আছে নেকি তাতে? তাতে প্ৰচিড কৰিলেইতো হ'ব। তাতে প্ৰচিড কৰিলে হ'ব। তাৰপিছত এইটোতো দৰকাৰ নাই ন? Well, it can be disposed of, if I'm not wrong, my lord. It can be disposed of since its suit is pending. Outcome of the civil suit will do. They can pray for injunction before the Munship or learned
What
Munship
is
court
the
will
subject matter of the civil suit?
saying that the petitioner is a lawful owner of land measuring thick as shown in the schedule below in the suit land. That is the same subject matter, same suit land.
Yes, Mr. Karim.
So it will be better for him to pray for injunction below the London Munship. That injunction pray for is better.
Suit is pending since when?
2013, my
13.
Lordship, actually, I have no communication with the petitioner, Lordship, last few months, Your Lordship. I have to take some time, Your Lordship, prayer. Your Lordship. Just prayer for some time, Your Lordship. What is the status of this?
তুমি এটা কাম কৰা, fix it tomorrow. কালি তুমি already instruction লৈ লোৱা. Stay খাই. Or after some time. নহ'লে first stay লৈ বহি আছে না?
What is the subject matter of the suit? Which document do you have, Mr. Das?
My lord,
Page?
Page 49.
49.
49, my lord. It's not a suit, it is an appeal before the deputy commissioner.
No, he has also mentioned about the suit.
Yes, my lord. Para 1, where the facts of the case has been mentioned, my lord. Here it says, my lord, page 50, para 4. That on there, after the petitioner being a landless lady, applied for allotment of abandonoma for the scheduled land before the deputy commissioner Dhubri, who after thorough inquiry found the petitioner in exclusive possession of the scheduled ceiling cast land and was pleased to use abandona in the year 2006-7, White Book 141, serial number. Para 6 says the land has got a patta also.
For
para 7 will clear everything. Para 6, 7 and 8 will clear everything, madam.
Heard Sri A.R. Karim, learned counsel for the petitioner. Also heard Sri N. Das, learned state counsel, and Ms. P.R. Mahanta, learned standing counsel revenue. The grievance of the petitioner is against an order dated 5/6, is it 5/6? Order dated 5/6/2017, issued by the Assistant Settlement Officer, Golagganj Revenue Circle, whereby the petitioner was directed to demolish her 3-storied RCC building and other structure within 15 days. Full stop. It is also the case of the petitioner that on the same subject matter, title suit number 442 of 2013 was pending before the Munsif number 1 Dhubri And in the same title suit, a miscase was filed on 9/6/2017, in which the hearing was fixed on 23/6/2017. First stop. It, however, appears that parallelly, the present writ petition was filed on 13 June 2017. Full stop para. This court wide order dated 16/6/2017 had issued notice and had also passed an interim order of stay of the impugned order dated 5/6/2017 till the next date fixed. Full stop. Para 3. Karim, the learned counsel, has, for the petitioner, has submitted that for a long period of time, he is not in touch with the clients and does not have the present instructions. Full stop. He has, however, submitted that as regards steps for this one number 6, he has taken such steps today itself. Such step today. Full stop. Para 3. And thus, the London State Council has, however, submitted that on the same subject matter, the suit mentioned above is pending. Full stop. He has also drawn the attention of this court to the appeal, to the representation submitted by the petitioner to the Deputy Commissioner on 12/4/2017, in which the fact of filing and filing of the civil suit has been revealed. Full stop. Para. After considering the facts and circumstances, this court is of the opinion that the subject matter of the present dispute being a matter of fact which are disputed in nature, and the said matter being before the competent civil court for adjudication, a parallel proceeding is not required to be continued. Full stop. Para. In view of the above, this writ petition is closed by giving liberty, closed. Full stop. In the event the title suit instituted in the year 2013 is yet to be complete, is still pending, the petitioner would be at liberty to file appropriate injunction application regarding the impugned cause of action, which otherwise also appears to have become odious. Full stop. It is also provided that the competent authority may take appropriate action in accordance with law for the land, for the plot of land in question. After 5 years, 7 years, what will the notice will have any meaning? No meaning.
Obligation.
Interim or vacated. Huh? Time being good to us. 36. 36. I don't. You are appealing, Mr.
Yes,
Chaudhary? Mr. Deka says that there is no appeal against Pankaj Mohan in spite of his search. Your colleague had made a submission on the last occasion that Pankaj Mohan judgment is presently tested in the division bench, it is pending. Do you have any instructions on that?
No, my lord.
Because Mr. Deka, without even going to the details of these facts, he has said that the issue has been already dealt with and decided.
Yes.
So we can apply Pankaj Mohan again and dispose this off. But your response of your colleague was that this was subject matter of appeal.
Yes, my lord, I had a talk with him, but due to some personal reason, he had to leave the court. Lordship, otherwise he is, he.
Well, then we'll have it this sometime later. Tell us when.
No, can it be next week? Maybe?
Next week, yes, it can be here next Wednesday.
Next Wednesday.
Okay. Part 3 BD Deca, Learned Counsel for the petitioners. Para. 3 B Chaudhary, Learned Standing Counsel, PWD, has however prayed for some time on behalf of his colleague, Sri P. Nayak, who is equipped with the instructions pertaining to this case. Para. On request, list on Wednesday.
Obliged.
There is one more matter, Mr.
Yes, ma'am.
In your affidavit, lot of discrepancies, mostly in the documents, have been cited by your colleague. What do you say on those?
Lordship, the discrepancies has been mentioned because under the act and the rules.
No,
those are the requirements.
No, on the enclosures, the enclosure which he has enclosed in his petition is different from your enclosure. Same thing. The notice itself. Something else has been written in his document. Something else has been written in your document. Page 26 and page 75. For instance. I think you file an rejoinder affidavit. There's an interim order protecting you. But there is some urgency on your part.
Because it's a perishable goods, Lordship, it's tobacco leaves. And we have to pay every day 7,000 to 10,000 rent of the conveyance, Lordship. Almost 1 month has been passed, Lordship. Even we are ready to file an bond of the bill amount. It may be kept pending, Your Lordship.
What about the suggestion made by your friend? What is your name?
Maulik Soni, sir.
Suni.
Soni.
Mr. Soni is saying that the clients are willing to provide a bond because he is concerned with the goods. If the goods are perishable in nature, then neither you get anything, neither he gets anything. Now, if he is not successful in this endeavor, then he is bound by the bond.
Because Lordship, on the investigation made by prima facie, the authorities are satisfied that there is something wrong in their.
No, that is why.
movement.
That is why.
And
that is why, Mr. Chaudhary.
Lordship, further proceeding is initiated, but they were uncommunicable to call for them for the verification.
No, that is why we are asking that if you are successful and the writ petition is dismissed, there still a bond will be there.
Lordship, on that part, Lordship may take it after some time. I will try to get the instruction over for.
Yes.
After some time, Lordship.
Yes. What kind of undertaking are you envisaging?
When we are ready to pay the tax penalty amount as per the bill, because it is a unmanufactured tobacco. Goods amount is 6 lakh rupees. Or this matter may be kept pending, Your Lordship. Even one more discrepancy, even my learned senior friend may take instruction just for their knowledge. Even in MOV 7, Your Lordship, what did they do? In MOV 7, they fixed the date of hearing on 5 July 2025. And very next page, MOV 9, which was issued on 26 June 2025. It's backdate.
Lordship, on that I have instruction. It was an inadvertent mistake by the authorities on the field. Lordship, because on the same day MOV 9 was issued. It was an inadvertent mistake. There was no other intention, Lordship.
No, only taking into consideration the nature of the goods. Since he is protected by an interim order, which may not help him tomorrow if there is further delay. So you take instructions on this part, whether even if we hear this matter at a later stage, something can be done with the goods in question.
Lordship, may allow me
what are the goods?
Unmanufactured tobacco, it's tobacco leaves, Your Lordship. leaves of tobacco, your lordship. Even this is in rainy season, your lordship. There is full chances of it will be put in hand, your lordship.
You're only on the aspect of, there is no illegality involved. Is there any illegal?
Lordship, the other, because number one,
No, apart from the duties part, is there anything else?
till now,
Is it permissible goods?
Lordship, permissible, but it has to, they have to have the necessary
No,
documents.
procedural part will
Procedural
take
part.
care, but we are asking a very primary question. Is there anything illegality of the goods? Not
And till now.
Then you take instructions.
Yes, on the bond part, Lordship,
Yes.
I'll have that.
We can have it tomorrow also. Are you an obsession council or what?
Please, I am coming from Gujarat. If it's subject to convince, my lord, I will stay here for tomorrow, or subject to.
Tomorrow we can have it as first item. Okay, let
Please,
him
sir.
have the instructions. Okay.
I'll have it.
Third, Sri M. Soni, learned counsel for the petitioner. Also, as well as Sri B. Chaudhary, learned training counsel, finance, bracket, taxation, bracket, close department. Correct? Though the department has filed the affidavit in opposition on 1/8/2025, comma, the learned counsel for the petitioner has submitted that the enclosures to the affidavit would show a large number of inconsistencies, both in the stand as well as the documents. Full stop. He has also emphasized that the goods in question are perishable in nature and therefore delay in adjudication of this matter would not serve the interest of either of the parties, though an interim order is protecting his client. Full stop. Para? No, para, no. He has also submitted that he has instructions to submit a bond till the adjudication of this case by taking into consideration that the goods are perishable in nature. Para? Sri Chaudhary, the learned training council, prays for some time to obtain instructions on the aspect as to whether submission of a bond would be an acceptable proposition. Full stop. Para? List, since urgency has been expressed, list this matter again tomorrow. Since urgency has been since considering the facts involved, list this matter.
Also, contempt matter, my lord. They have filed affidavit, my lord. I have to file affidavit in reply with up to date status. Time may be given, my lord, within one.
Who is for the, you have filed your affidavit?
Already filed.
Is there anything, a willful violation?
Yes, my lord.
What kind of willful violation?
Not
They
willful
were
violation, my lord.
instructed.
That has been already complied with.
Complied with?
Yes.
As per instruction, my lord, they constructed the house, my lord, even in the ground floor, my lord.
What was the order of this court?
Currently see page 27, my lord.
27.
There are 11 persons, 6, there are 6. No?
Yes, please. Chairman,
Taking into account.
Yes.
the-
You have done that exercise, Mr. Khan? You have done that exercise?
Yes. Already.
Where is it?
We have mentioned in, kindly go through,
You have filed your affidavit?
affidavit we have filed. In para number 10, my lord.
Para 10?
Yeah.
This has been complied with, Mr. Bormon.
My lord,
Contempt petition is not to make a roving inquiry.
my lord,
We're only to oversee whether the order of this court has been willfully flouted, violated, or has it been complied with. These are compliance.
that is important.
Now, if you go into the facts, You have to challenge the order, subsequent orders, not in a contempt petition.
That is why, my lord, they even
Why should unnecessarily this be kept pending? This,
they not concluded the inquiry even, my lord. The construction made by the, my lord, even ground floor also, my lord, not following the terms of the building bylaws. There is no inquiry report even in next with the, my lord. As per the para 6,
pillars have already been demolished by the incumbent Badal Soom.
Yes.
What else is there?
there is, the pillar is on the, my lord, first floor, my lord.
These you have to, and see the photographs.
That is, I saw it, my lord, but it shows the pillar of the first floor, not the ground floor, my lord. They constructed the ground floor, my lord, even in my boundary, above my boundary.
No, let us see again. Let us again see the direction of this fort.
Can you see
Page
27, my lord? Para 6 is the relevant portion. Started from the
taking into account disposal of the writ petition with direction to the chairman to make an inquiry as to whether the respondent number 5 is Badal Shom.
Yeah.
Had made construction in terms of the permission approval so granted, and if not, then take. Where is the reference to any ground floor, first floor? Where?
Kindly go to para 5 also.
No, just a minute. Mr. Burman, where is the reference to any ground floor, first floor?
that was not given, my lord.
No, that is not the direction of the court. Direction of the court is to make an inquiry whether the construction made by respondent number 5 is in accordance with the approval, and if it is not, to demolish them. Those have been demolished. And see the observation of this court that these are all civil matters. It cannot be gone into
Exactly.
Heard.
My lord, like instruction maybe, my lord, taken from the client, my lord.
Heard. Sri N. Burman, learned counsel for the petitioner. Also heard Sri S. C. Khan, learned counsel for the sole respondent who has filed affidavit in opposition on 12th of July 2024. Puts the para. The instant petition has, please have this it. Instant petition has been filed alleging willful and deliberate disobedience of an order dated 11/8/2023 passed by this court in WPC 1734 of 2017. Puts the, for ready reference, the operative part of the order dated 11/8/2023 is extracted herein below, page 26, para 5 and 6, para 6, 7. Full stop. Para. Sri Burman, the learned counsel for the petitioner, has submitted that the said part has not been complied with. Full stop. Para. After issuance of notice, the sole respondent had entered appearance and thereafter filed the affidavit in opposition as noted above. Para. Recount the learned counsel for the respondent, by drawing the attention of the said affidavit in opposition filed on 12/7/2024 has submitted that the direction of this court has been fully complied with. Full stop. He has drawn the attention of this court to the averments made in paragraph 10 of the said affidavit in opposition, which reads as follows, page 107, paragraph 10. He has also drawn the attention of this court to the various photographs to show photographs enclosed to the petition, enclosed to the affidavit in opposition to show the steps taken for dismantling the pillars which were found to have been constructed without approval of the authorities. Full stop para. 3. Vermont the Learned Counsel for the petitioner has submitted that the pillars pertain to the first floor and not the ground floor. Para. After consideration of the rival submissions, this court has also noticed that while disposing of the writ petition via the order in question, this court has also noted that the dispute otherwise was civil in nature and can be dealt with by an appropriate civil court. Full stop. Be that as it may, from the averments made in the affidavit in opposition, which are supported by the intruders, including the photographs, this court is of the opinion that the order of this court has been substantially complied with. Full stop. Accordingly, the purport and ambit of this court exercising contempt jurisdiction is only to oversee as to whether a direction of this court has been willfully flouted, which does not appear from the facts and circumstances of this case. Full stop. Accordingly, the contempt petition is closed.
Obliged.
45. 4-5.
May I please, Your Lordship. My lord, order, my lord, at page 46, my lord, 11 page. Otherwise, my lord, on the last two occasions, they have taken time to file affidavit, my lord. 129/11.
46, what is the direction, Mr. Mullah?
Direction, my lord. Page 46/12, my lord. Situated thus, this writ petition is being disposed of with a direction upon the respondent numbers 3, 4, and 5 to verify the claims of the petitioners. Upon such verification, if it is found that the petitioners are the genuine residents of Gornagar Gao Panchayat and are similarly situated as the other beneficiaries of the Gao Panchayat, then in that event, necessary steps for inclusion of their names in the list of beneficiaries in respect of the Gornagar Gao Panchayat be initiated. Upon completion of said process, the claim of the petitioners for extending the benefit under the PMAYZ scheme be also considered and processed in accordance with
Yes,
law.
madam.
Lordship, we have got the instruction also.
You have done a verification
Lordship,
exercise.
we have
Not done.
We have done.
Done it. Mullah?
After verification, Lordship, out of 40 petitioners, Lordship, 6 numbers are already enlisted. 4 numbers have been found ineligible and 29 numbers are maybe enlisted, Lordship. So, Lordship will obtain the.
You give a copy to this of the
Lordship.
third. 3. AFNU Mullah, Learned Counsel for the petitioners. Also heard Ms. P. Thapa, Learned Counsel appearing for the respond number
3, Lordship.
3. Sri Mullah, the Learned Counsel has submitted that
Lordship, 1 also.
1 and 3, huh? 1 and 3. Okay. Learned Counsel has submitted that the present petition has been instituted an order dated
26/9/2023
passed in the connected WPC 166 of 2022. Full stop. In the said order, there was a direction for undertaking a verification exercise of the petitioners so as to include their name in the list of beneficiaries in respect of Gornagar Gao Panchayat in the district of Gwalpara. The Learned Counsel has submitted that the aforesaid direction has not been complied with, and accordingly the present petition has been instituted. Para. Ms. Thapa, the learned counsel for the respondents, has however submitted that instructions have been received as per which the order in question was duly complied with, full stop. By referring to the written instructions, comma, a copy of which has been placed before this court, comma, the learned counsel has submitted that out of the 40 numbers of petitioners in the writ petition, 6 were already enlisted in the permanent wait list within bracket PWL bracket close of the PMAY-G under the concerned Gaon Panchayat and would be benefited as soon as the allotment is made. Full stop. It is also provided that 4 numbers of petitioners have been found to be ineligible for the benefit, and the remaining 29 numbers of petitioners would be enlisted in the PWL of the PMAY-G following the guidelines. Tara? Considering the aforesaid instructions, this court is of the opinion that the order of this court has been substantially complied with. Full stop. The petition is accordingly closed. Para, a copy of the written instructions dated 9/9/2024 is made part of the records. What is the yes. Oh, we have to rise early. Is there any urgent matter? Then we have to fix.
My lord, may I please one thing, my lord. The names of 4 petitioners, my lord, whose name have been, who are deprived, my lord, rejected. Their names, my lord, not mentioned in this name.
The petitioners who have been held to be ineligible would be at liberty to challenge the aforesaid decision in an appropriate proceeding. Right now saying that she will not be able to help you. You have to-
Item number 40 order will be expired on payment. Item number 40.
40.
48.
48. What is it? Interim order.
Interim order will be expired today, my lord. This is a case Article 20, subsection 2 of the Constitution. of
Double
India.
jeopardy.
My point is that, my lord, in this case, my lord, one offense, my lord, and there are 2 FIR, my lord.
It seems you have seen Andha Kanun yesterday.
Yes, my lord.
You have seen yesterday.
That is the case, my lord.
You are faced with double jeopardy.
Yes, my lord. This is case of double jeopardy.
Okay, when can we have? Is it assigned to this bench? Yes.
Yes, my lord.
And who's for the other side?
Number 2 is an MLA.
You are there for the other side?
Yes,
Okay,
Lordship.
when can we have? Tell us.
As well, Lordship.
Please do not suggest this week. This week, this court will not be there.
My lord, then, my lord, your
Next
lordship
week, next week after
after
Tuesday.
Independent Day, my lord.
Why?
8/20, my lord. 20 August. Have na?
After Independence Day,
Yes, ma'am.
you want to be independent.
Yes, my lord. Or earlier, there is your lordship.
You suggest?
20 August.
This is a revision.
Yes, my lord.
What is the cause of action?
Cause of action is that, my lord.
Now, what are you challenging?
I am challenging for one offense.
No, that is, I understood. That is the principle of
Yes, ma'am.
challenge. What is
Framing
the
of search, framing of search.
charge framing?
Yes, my lord.
How is it double jeopardy?
Double jeopardy means, my lord, earlier there are 6 FIR has been filed in this case, my lord. 5 FIR has been amalgamated. 1 FIR, my lord, in this case, my lord, for the same offense, file separate charge sheet, my lord. I can show your lordship, the witnesses are same, postmortem report are same, sketch map are same, and the same section, my lord, IPC section, my lord. So that cannot be done, my lord. Either they amalgamate all this FIR or disseminate.
What is your stand, madam?
And this, another thing is that this Jamini Saranya file another affair which has been amalgamated, my lord, in fast.
Now, what is your stand, madam? Why is it not double jeopardy?
Lordship, there are 2 FIRs has been initially lost by 2 different persons, Lordship.
Now, if the subject matter is the same,
Lordship.
can you proceed in 2 cases? You cannot.
That cannot be other.
So do you allow the petition today?
No.
No, don't need. Why?
Because she will be in trouble, my lord.
Why? It's the court's order.
Because petition
Why-
on.
why would anybody be in trouble?
Because of petition on number 2, my lord.
Huh?
Because as my lordship, as per office note, a service report is awaited in respect of the respondent number 2.
Who's two?
Lordship, that is one
My-
private
Your
respondent,
lordship kindly paid us 1/8/2000.
and there is a note that
Okay, we'll consider this after, not today.
Yes,
Oh,
lordship. Lordship, item number 55 was there only for a small correction, lordship.
We have not passed order in this case. Why
Yes,
don't you wait for your turn?
Okay.
Cannot pass orders together in all cases. 48, huh? Paucity of time may not allow the matter to be taken up today. As on a joint request, leave this case on.
by state,
By state.
on 22nd of August.
Can it be, my lord, earlier, my lord?
We'll have it on 18th,
Yes, ma'am.
Lordship,
18 August,
Yes, ma'am.
lordship.
Monday.
Well, can it be 19, ma'am?
19. 19. Para interim order passed earlier to continue
That's
till the
fine.
next date of list. Yes, Mr. Agarwal?
Lordship, yesterday the matter also came, lordship, there is 55 item number, that is a small correction that.
Other side is there.
Yes.
Yes. What correction?
That if earlier 50% we have not withdrawn, so that may can be withdrawn.
The
That
ST
is
may be
the-
directed to release the earlier deposited amount, lordship.
Was there any direction on the to the contrary?
No, in the, at the time of Lokata, we have mentioned that we have withdrawn, but it was actually not withdrawn.
Part 3A R. Agarwal, learned counsel for the applicant. Also heard 3, what is your name?
R. Sharma, lordship.
R. Sharma, learned counsel for the
Insurance company. lordship.
insurance company, full stop. This matter was settled in the Lok Adalat, which was held on
8/3/25.
8/3/2025. Full stop. Sri Agarwal, the learned counsel for the claimant, has however submitted that due to inadvertence, an incorrect submission was made regarding the deposit of 50, regarding the withdrawal of the deposited amount, of the 50% deposited amount. Full stop. He has clarified that such withdrawal was not made earlier, and therefore the said aspect is required to be corrected, required to be clarified in this, clarified by this court. Full stop. Sri R. Sharma, learned counsel for the insurance company, does not object to the aforesaid para. In view of the aforesaid facts and circumstances,
Petition respondent number 1.
it is clarified that the earlier deposited amount of 50% of the award be also released to the claimant.
Claimant number 1.
To the claimant number 1, which is to be, who is to be identified by the learned counsel. It is lying in this court.
Yes, Lord.
It is to be released by the registry. Okay, rest dates will be given.
Only one, I have interim order, my lord, item 50.
It will be extended, don't worry.
Only one, if your lordship remembers that district commissioner, the Gwalpara to be written, I have written Dubri as a.
Okay, yes, I unit had filed.
Yes, my lord. File, my lord.
Which I?
My lord, item 56, my lord.
Will come for motion.
Yes, my lord.
Will come for motion tomorrow.
Your lordship was about to give the interim order, that time this was
No, but
pointed
it's
out.
not listed for motion today.
No. It was only for that
He too has any motion. Motion motion to one.
I think this part has to be corrected then.
No, we'll do it. We'll list it for motion. Huh? Item number
56.
On
Wednesday, my lord.
Yes. You can have it tomorrow also.
Tomorrow also.
It will be list this item under the motion, under the motion column along with the I.
Yes. Deeply obliged.